Good morning, everyone. I'm Judge Corey Amanda Coughlin, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, and I encourage you to speak with your attorney before speaking on the record today, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, please know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom and are able to address your case from here. If your attorney is not in the courtroom when I call your name, then you can let me know that and we will see how we can best facilitate you through that process. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have attorneys present from the State Attorney's Office, as well as representatives from confinement status, pretrial supervision, and the Clerk of Courts. All of these persons are here with us this morning to help facilitate the morning session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at First Appearances if you are here on misdemeanors or municipal ordinance matters, but please understand that is dependent on what is going on with you personally and your case. For those of you here on felony matters and violations of probation where the judge has already set a no bond hold, know that that cannot be changed or resolved here at First Appearances. After today, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before the division judge. Now, I'm just going to say to those of you at the main jail, I have been told by the IT department this morning that apparently we are having a problem with the feed to the other jails. So I'm going to do my best to go through our list today so that we can address those at Maine first, and hopefully by the time that we're done with those cases, the issue will be resolved with regard to the other cases. As you know, I have the paperwork in front of me that doesn't indicate where someone is, so if I call a name and that person is not at Maine, please let me know and I'll just put it on recall and we'll come back to it once we have that issue addressed.
Yes, sir.
I do have 3 cases that I've been made aware have been requested to be called out of term by the jail. So Mr. Romero, please just let me know if they're not at Maine, then let me know and we'll come back to them. The first on my list is Philip Jackson on
He's
page
here,
7.
Seven.
Thank you. Paul Ryan's back up? Okay. Paul Ryan is back up, I'm being told. All right. So we can do cases at Maine and at Paul Ryan for now.
Yeah,
All right.
we'll have you on.
Thank you. All right, good morning, Mr. Jackson.
Good morning.
Mr. Jackson, you are before the court this morning on an ad charge. This is a charge for aggravated battery with a deadly weapon, dating violence. I find probable cause. And Mr. Jellin, are you here on this case or a different case?
No, I'm sorry. I was just getting ready for the next.
Okay, all right, I just wanted to make sure. All right, I'll wait for the parties.
I'm going to be asking for the court to consider releasing Mr. Jackson. Basically, ROR pretrial or at the minimum $1,000 bond. My understanding is Mr. Jackson's been in custody now since I believe June of last year. He was being held on a similar offense, no bond. My understanding, he resolved the matter. He showed me paperwork. He was actually given probation. I believe it was similar in nature, and I believe maybe even the same victim. And I believe the reason why the state extended a probation offer is the victim was okay with it and didn't want to follow through. As you see here, we have a domestic situation. I believe it's the similar victim. That's why I believe it's reasonable considering he's going to be already on supervision. He's been in custody, so financially he hasn't been working, has no monetary assets or anything like that. That's why I'm asking for the court to consider one of the 3 options I asked for, Judge.
Your Honor, I'm going to be requesting a $5,000 bond. It is not the same victim. The aggravated battery, he just resolved the allegation was he threw and hit the victim in the head with a brick. I'm also concerned, even if he's on probation, that doesn't resolve concerns for this particular victim. As you can see, he threatened the victim saying, "You're lucky I don't kill you because I love you." When she responded to him out of anger, he hit her in the head with a stone. And officer documents the injury she suffered, swelling to her face to the point where her eye was closed, and she had to be transported to the hospital.
I just want to be clear. One moment, Mr. Mayor. I just want to clarify something. So you're telling me that the other case is a different victim and that involved being hit with a brick?
Yes.
Okay. All right. Yes, Mr. Romero.
Judge, my understanding, then I've been corrected by the state, different victims. However, as you are aware, he's been in custody since last year, so this isn't something recent. It was prior to him being incarcerated. Obviously, he hasn't been working. He has no sort of financial resources. Now, when he gets out, I believe his brother lined up a job for him. He does have family that he's going to be relying on to help him get back on his feet. So in that case, Judge, considering he is going to be on probation, and if he violates his probation, then he faces serious ramifications on the case that he already pled to. So I believe $1,000 bond is reasonable under the circumstances, Judge.
Your Honor, he faces serious ramifications potentially for an aggravated battery. You know, being up, I've already stated my argument.
I'm going to set the bond at $3,000. There will be an order of no victim contact. Mr. Jackson, no victim contact. Beans, no being in the same place at the same time. No phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes.
Thank you. Case that the jail is requested to be called out of turn is Najee Jackson.
He's approaching, Judge.
Thank
on
you.
Page 33. Okay, Mr.
Sorry.
Jackson, come on up,
Wait,
please.
like 33 or 35.
Good morning, Mr. Jackson. Mr. Jackson, you're before the court this morning on one charge for first-degree premeditated murder. I find probable cause. I'll hear from the parties.
Your Honor, the state would be seeking a finding of proof evident or presumption great and that Mr. Jackson be held no bond for first appearance purposes. The court is familiar with the probable cause affidavit. Mr. Jackson was observed by two witnesses leaving the backyard of the residence where the victim was shot immediately after shots were fired. He's been identified from surveillance video by his own mother. She identified his cell phone number where texts were sent. There was a conversation with the victim where the person sending the text messages threatened to kill the victim prior to the shooting. And I would also note, lastly, Your Honor, that in a post Miranda statement, Mr. Jackson admitted to killing the victim, shooting him 5 times.
We have no comment on the proof evident presumption great aspect, Judge. However, at this time, we would be invoking Mr. Najee Jackson's Fifth Amendment right to remain silent, and we're advising the state that neither they nor any police agency attempt to contact Mr. Jackson or speak with him about this case without first contacting his attorney. Also, Mr. Jackson, I am advising you, do not discuss this case with anyone. Do not talk about the case with anyone in the jail. Do not talk about the case with anyone on the phone. Your conversations are being recorded and they are listening. And anything you say will be used against you later. The only person you should be discussing this case with is your attorneys. Do you understand me, sir?
Yes.
Okay.
All right, thank you. At this time, the court is going to make a preliminary finding of proof evident presumption great as to this charge. Mr. Jackson will be held without bond. This is without prejudice for him to have a hearing before his division judge as to this matter. Thank you. All right, the third case that I have the jail requested to be called out of turn is Selvin Soto. on
He's in
page
Paul Ryan,
35.
Judge.
Okay, I'm able to do the Paul Ryan cases, I'm being told. So let's just see, let me go to Paul Ryan. Thank you. All right, he's on page 35. Good morning, Mr. Soto. Mr. Soto is before the court this morning on one change of charge and 2 add charges. The change of charge is burglary with assault or battery. The 2 add charges are for first-degree petty theft and for criminal mischief, $200 or less, first offense. I'll hear from the parties.
Your Honor, just a brief history of this case. When Mr. Soto, I know it says change of charge from armed burglary.
Yes.
When Mr. Soto was first arrested, that was a charge in error. There was no mention of a weapon involved. So I think this is Judge Powell. Judge Powell found for burglary of an occupied dwelling or structure and set a $25,000 bond, level 2 pretrial with the GPS, no victim contact, no return, and an abundance of caution order, no weapons or firearms. Yes, Judge. She said a $25,000 bond, and just so you know, I'm going to be asking for the same.
I understand, that's why I wanted you to repeat it.
Pre-trial with a level 2 GPS, no victim contact, no return, no weapons or firearms. Even though the state has upfiled this to a punishable by life offense,
Yes.
considering that Mr. Soto is also being held no bond on a separate aggravated battery, I'm just asking that the court keep the bond and release conditions that Judge Powell originally set in place.
That's fine, Judge. He has to go in front of his division judge to address those issues in any event.
Okay, all right. In light of that, I will adopt Judge Powell's prior finding as to the burglary charge. The standard bonds will remain in place on the 2 add charges. So just to recap, the bond on the burglary charge will be set at $25,000. And if Mr. Soto does post his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. The no victim contact order will remain in place. The no return order will remain in place. And there will be an order that Mr. Soto possess no weapons, firearms, or ammunition. Mr. Soto, do you understand those conditions?
Yes, ma'am.
Thank you. Yes, thank you. All right, thank you
Our
very much.
Spanish and Creole interpreters are present, Your Honor.
Thank you. We only have a few, just so we can get our interpreters out of here. On page 11, Miguel Gonzalez Soria. Which facility is he at? Thank you. And for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor. For the record, Moises Hernandez.
Thank you, Mr. Hernandez. Good morning, Mr. Gonzalez.
Buenos días, señor González.
You're before the court this morning
Se encuentra ante el tribunal en la mañana de hoy,
on one charge for trespassing,
acusado por un cargo de presencia no autorizada o entrada no autorizada
an occupied structure or conveyance.
en una estructura ocupada o en un vehículo.
If I'm probable cause,
Encuentro que hay causa probable o fundamentos para procesarlo.
and I will hear from the parties.
Escucharé de las partes.
Judge and speaking, Mr. Gonzalez, he wishes to resolve this matter, so we wanted to see if the state had a plea offer for him
Su
today.
señoría, conversé con el señor González, él desea resolver este asunto, así que deseamos que se resuelva este asunto con una declaración de no oponerse.
You withhold the court costs.
Sería una suspensión de adjudicación y el costo de las costas del tribunal.
Judge, he wishes to accept the state's offer.
Su señoría desea aceptar la oferta de la Fiscalía Estatal.
Mr. Gonzalez, please raise your right hand.
Señor González, por favor levante la mano derecha.
Do you swear or affirm to tell the truth?
¿Jura usted decir la verdad o afirma decir la verdad?
Yeah.
Thank you. You can put your
Muchas
hand
gracias.
down.
Puede bajar la mano.
Mr. Gonzalez, do you understand everything we've discussed so far today?
Señor González, ¿entiende usted todo lo que hemos conversado hasta ahora?
Sí, yo puedo decirle algo.
Yes, may I say something?
Oh, Judge, I answered his question, and I believe he has no more questions. We're ready to proceed forward.
Su señoría, contesté sus preguntas y entendemos que no tiene ninguna otra pregunta, podemos proceder.
Mr. Gonzalez, is anyone forcing you to resolve your case?
Señor González, ¿alguien lo está obligando a resolver usted su caso?
No.
No.
Are you under the influence of drugs or alcohol?
¿Se encuentra bajo la influencia de drogas o alcohol? No.
Do you need any more time to speak with your attorney?
¿Necesita más tiempo para hablar con su abogado?
No.
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea?
¿Entiende usted que tiene derecho a un juicio en su fondo, pero que está renunciando a ese derecho al llegar a un acuerdo con la fiscalía?
¿Qué?
What?
Repetir?
Do you
Can you repeat?
¿Entiende usted?
Do you understand that you have the right to a trial, but
Entiendo.
you are waiving that right by taking a plea?
¿Entiende usted que tiene derecho a un juicio, pero que está renunciando a ese derecho porque está llegando a un acuerdo?
Yeah.
Okay. Have you ever been treated for mental or emotional illness?
¿Ha recibido usted alguna vez tratamiento por alguna enfermedad mental o emocional? No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
¿Entiende usted que de no ser usted ciudadano de los Estados Unidos, que llegar a un acuerdo puede exponerlo a la expulsión o a otros cambios en su estado migratorio?
Okay.
Ok.
And what plea do you wish to enter, guilty or no contest?
¿Y cómo desea usted declararse? ¿Culpable o que no se opone a que le adjudiquen culpabilidad?
No contest.
No contest.
All right, I accept your plea
Muy
and
bien,
find that it
acepto
is
su
freely and
acuerdo.
voluntarily given.
Entiendo que se ha dado libre y voluntariamente.
Your sentence will be a withhold of adjudication
Sus-
plus court costs.
Su sentencia será una suspensión de adjudicación y el pago de las costas del tribunal.
Good luck to you, sir.
Buena suerte, señor.
So everyone knows I'm being told that Conti is back online as well. North Broward's the only one that we're waiting on now. Next will be Ernesto Cordero Hernandez on page 13.
He's approaching, Judge.
Good morning, Mr. Cordero Hernandez.
Buenos días, señor Cordero Hernández.
Buenos días.
Good morning.
You're before the court this morning on one charge of second-degree petty theft.
Se encuentra usted ante el tribunal en la mañana de hoy acusado de un cargo de segundo grado de hurto menor.
I find probable cause.
Determino que hay causa probable o fundamentos para proceder.
I'll hear from the parties.
Escucharé de las partes.
Judge, regarding Mr. Cordero, I'm going to be asking the court to consider releasing him ROR.
Su señoría, con relación al señor Cordero, voy a solicitarle al tribunal que lo suelte por su propio reconocimiento.
I believe my request is reasonable considering this is non-violent. He advised me this is the first time being arrested in his life.
Entiendo que mi solicitud es razonable porque el delito no es violento y que él me ha dicho que esta es la primera vez que lo han arrestado en su vida.
Now, he's been living here in our community for about 1 year now, and he lives in Miami with his aunt.
Lleva viviendo aquí en nuestra comunidad por espacio de 1 año y se encuentra viviendo con sus tías en Miami.
He also works here locally. He is a painter.
También trabaja aquí localmente, es pintor.
So, Judge, considering this is non-violent, he works here, he lives here, that's why I'm asking for an RR on his behalf.
Por lo tanto, su señoría, considerando que el delito no es violento, que trabaja aquí y que vive aquí, por eso estoy solicitando que lo liberen bajo su propio reconocimiento.
Your Honor, I'm fine with that.
Señoría, me parece bien.
Would ask for an order of no return.
Solicitaría una orden de que no regresar,
So Mr. Cordero Hernandez is aware.
siempre y cuando el señor Cordero Hernández sea consciente
The address the clerk will have is 1258
que la dirección que tiene la Secretaría del Tribunal es la 1258
Northwest 58 Terrace,
Northwest 58 Terrace,
apartment 5 in Miami.
apartamento 5 en Miami.
If that's not where he resides, then he needs to update the clerk's office.
Si ese no es el lugar donde él reside, tiene que actualizar la información con la oficina de la Secretaría del Tribunal.
That is his address.
Esa es su dirección.
All right, this charge will be an ROR.
Muy bien, entonces en este caso será una liberación por reconocimiento propio.
Mr. Cordero, so that you understand,
Para que tenga usted entienda, señor Cordero,
though you are going to be released today,
aun cuando lo vamos a soltar en la mañana de hoy,
that does not mean that that's the end of this case,
eso no significa que este caso ha llegado a su fin,
which means it will be your responsibility to follow up with your attorneys,
lo cual significa que recae sobre usted la obligación de darle seguimiento al caso suyo con su abogado,
as well as the clerk's office,
así como con la oficina de la Secretaría del Tribunal,
so that you know about any future court dates that you must be present for.
para que usted siempre quede enterado de cualquier fecha futura del tribunal a la cual tenga que presentarse.
There will also be a no return order,
También habrá una orden de no regresar,
which means you are not to return to the Nordstrom that is at issue in this case,
lo cual significa que usted no debe regresar a la tienda Nordstrom.
Do you understand that, sir?
¿Entiende usted eso, señor? Yes.
All right, thank you.
Muy bien, gracias.
Is there anyone else at Maine that needs a Spanish interpreter?
¿Alguien más necesita de algún intérprete de español?
No, not at this time, Judge.
Is there anyone at Concy or Paul Ryan that requires a Spanish interpreter?
¿Alguien en Conti o Paul Ryan que necesita un intérprete de español?
Not that I've been advised, Your Honor.
Okay, thank you. Thank you, Mr. Hernandez.
Thank you, Judge.
All right, I have two cases for our Creole interpreter that I will take now. On page 12, Jean Bellany.
He's approaching Judge Maine.
Thank you. And for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Creole to English and English to Creole to the best of your ability? Thank you, Ms. Senage. Good morning, Mr. Bellany.
Bonjour, Monsieur Belloni.
Bonjour.
Good morning.
You're before the court on a traffic capias.
Una tribunal nan la pou yon mandat, yon ticket circulation.
This is a charge for failure to register a vehicle.
Et c'est une accusation que ou pat enregistre machine nou.
I find probable cause and I will hear from the parties.
Jwen cause probable, ma poute tout participant yo.
Judge, my understanding is Mr. Bellamy, his state sentence, I believe his EOS date is February 1st. I'm going to ask to resolve this case today.
Ma mande pou nou rezoud ka jodi an, paske se février, 1er février yon swali.
Withholding court costs, Judge.
Oui, nou pa kondane, nap lap gen frais tribunal pou paye.
Wishes to accept the state's offer, Judge.
Nap aksepte.
Mr. Bellany, please raise your right hand.
Monsieur Belloni, leve men droitou.
Do you swear or affirm to tell the
Est-ce que
truth?
sincèrement affirmé pour dire la vérité?
Oui.
Yes.
Thank you. You can put your hand down.
Descend mail.
Do you understand everything we've discussed so far today?
Est-ce qu'on comprend tout ça que nous faisons parler sur l'île ce matin?
Oui.
Yes.
Is anyone forcing you to resolve your case?
Est-ce que gen moun kap forcé ou pour résoudre ka jodi an?
No.
No.
Are you under the influence of drugs or alcohol?
Est-ce qu'on sou effet drogue avec alcool?
No.
No.
Do you need any more time to speak with your attorney?
Est-ce qu'on besoin plus de temps pour parler avec avocat?
No.
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Est-ce qu'on comprend que ou gen droit pour aller dans jugement, mais ou quitter droit ça pour ka accepter offre là?
No.
No.
You do not understand that, sir?
Ou pas comprendre ça?
Répétez ça, Dia.
Repeat
Can
what
this
you
interpreter
said.
stand closer to the microphone?
Do you understand that you have the right to a trial,
Est-ce
but
qu'on
you
comprend?
are waiving that right by taking a plea today?
Est-ce qu'on comprend que ou gen droit pour aller dans jugement, mais ou quitter droit ça, ou perdre droit ça parce que ou voulez accepter yon offre?
Oui.
Yes.
Have you ever been treated for mental or emotional illness?
Est-ce que yo jam traité ou pour problème mental?
No.
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Est-ce que vous comprenez le fait que vous acceptez offre ça, ça qu'a fait au sujet immigration ou bien déportation?
Oui.
Yes.
And what plea do you wish to enter, guilty or no contest?
Ki jon vle deklare, koupab ou bien pap konteste?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. Your sentence will
Merci.
be a withhold of adjudication and court costs.
M'aksepte deklarasyon mwen kon fèl avèk tout prop volonté ou, sentansou se frais tribunal lan e nou pou kwa kondane ou.
Good luck to you, sir.
Bonne chance, monsieur.
I have one more Creole case, Jean Franz, on page 28.
Jean-France,
She's approaching, Judge.
Thank you. Good morning, Mr. Franz.
bonjour, monsieur France.
Bonjour.
Page
Good
28.
morning.
Mr. Franz, you're before the court this morning on 2 charges.
Ou devan tribunal lan pou 2 akuzasyon.
One is for trespassing on school grounds.
Yon kote entre ilegal nan l'ekol.
2 is for possessing forged bills or notes.
Deuxième akuzasyon se pos kote genyen fol ajan.
10 or more.
Plus, 10 ou plus.
I find probable cause,
Mjwen koz probab,
and I'll hear from the parties.
map koute patisipan yo.
Judge, at this time, nothing to add from the defense.
Juge pou le mouman, defense pa di rien.
Your Honor, just request an order of no return to Flanagan High School.
Jus nap mande pou pa retounen nan l'ekol Flanagan nan.
All right, the standard bond will remain in place on count 2,
Ke ap toujou genyen menm kosyon an pou akuzasyon 2,
and there will be a no return order to Flanagan High School.
e ap genyon lot pou pa retounen nan l'ekol Flanagan.
Mr. Franz, do you understand that?
Esko kompren, Monsieur France?
Oui, là, Madame Juge.
Yes, ma'am.
All right, thank you. Good luck.
Bonne chance.
Is there anyone else at Maine that needs a Creole interpreter?
Eske genyen lot moun ki bezwen interpret kreol?
No, not here, Judge.
Is there anyone at Concy or Paul Ryan that requires a Creole interpreter?
Eske genyen lot moun ki bezwen interpret kreol?
Not that I've been advised, Judge.
Thank you, Ms. St. Ange.
My pleasure, Your Honor.
All right, I have a couple of cases that have sign-ins. On page 3, Catrice Stewart.
She's approaching, Judge. She's here at Maine.
Thank you. She has family present.
Yes.
For her family members, let me just ask, because I know that there are a group of you here. Are you here just to observe or to speak today? Okay. All right, Ms. Catrice Stewart, you are before the court this morning on 1 charge for aggravated fleeing with injury or damage. I find probable cause. And let me begin. Sir, since you did indicate to me that you want to speak, I just want to remind you what I tell everyone at first appearances. Everything that we say is being recorded and can be used against her and potentially you at a later date. Do you understand that? Okay, if you wish to speak, I'm going to swear you in and then I'll let you tell me what you want to say, okay? Will you raise your right hand? Do you swear or affirm to tell the truth? And will you please state your name?
James,
Will you spell your last name?
Samuels. It was like, from my understanding, was
Can I have
We
you?
can't hear him.
I understand. Just speak into the microphone so they can hear you.
from my understanding was like kind of a misunderstanding what happened when she got arrested in Miami, because she had a license or whatever, and it was issued to her, and then after the initial, she got her license, then the warrant was issued after.
So that you understand, because I'm not sure what the license issue is that you're referencing, the charge that she's here on today does not involve a license issue. Okay? All right, is there anything else that you want to tell me? All right, so what I'm going to do now is, because since this is first appearances, I'm just dealing with bond and release conditions. So I'm going to hear from both of the attorneys, and then I'll make a decision on that. Yes, just speak into the microphone so they can hear you.
See, her kids are here, all 4 of them. Like, they need their mother. I'm like, that's why I'm really here with them, to show you that, like, we here for her. They're like, they're missing their mother. They need to go to school. It's like we're in kind of a bind, moving situation-wise. Just got put out of our house, bouncing around, and it's like
Sure,
all
I'll take
this
them
just
at
came
26.
down on at one time. Like,
Hold on just one
Right
second.
now, we all split up right now. They're on one side, she's here, everybody's split up. I'm just trying to get everything back where everybody's at and on one accord right now.
Mr. Samuels. Okay, so now I will hear from the parties, and then we'll go from there.
Requesting a $2,500 bond. This is a filed second-degree felony, and the only reason that it's only coming up now is because Ms. Stewart fled from law enforcement. She drove in a reckless manner that it was no longer safe for the officer to continue following her and had to discontinue his pursuit, in which Ms. Stewart apparently would appear fled into Dade County, Your Honor. I would also note, without going into detail, but Your Honor sees it, her conduct once she first stopped and her interaction with the officer before she then fled, noting that she almost caused a serious accident with oncoming vehicles. Based on the nature of these allegations, I do have a concern about her future appearance in court. I see history, it is dated, so my concern isn't necessarily having to do with her with any criminal history.
Carol?
Judge, I'm gonna be requesting what Ms. Stewart has advised me to request. She is wanting the court to release her on straight ROR. Now, my understanding, Judge, she was initially, I believe she was extradited from Dade County. She's been in custody now for what she advised me about 10 days. Now, she's been living in South Florida her whole entire life. My understanding at this time, she's unemployed, she's not working. From what she advised me, she's basically in between places at this time. Also, what she advised me, Judge, is she was trying to get information in reference to this case in Broward County, but she couldn't obtain any sort of information. She also did advise me she's trying to get her driver's license as something, or she obtained her driver's license. But my understanding, Judge, right now, considering from what the state is saying that this was allegedly happened last year, that's why she's only requesting a straight ROI at this time.
All right, based on the nature of the charge, I'm not willing to give her a straight ROR. I will set bond at $2,000. Okay? Thank you. All right, good morning, Mr. Jelen.
Mr. Sierra Victor on page 20.
Yes. Do you have Victor Sierra, Mr. Romero?
Right here,
Okay.
Mr.
All right, good morning, Mr. Sierra. You're before the court this morning on 4 charges. 1 and 2 are felony violations of probation. Those each have a no bond hold with the hearing set before the division judge tomorrow morning. 3 and 4 are each a capious misdemeanor. Those relate to charges for a dog bite where owners are liable for their dogs and owning or controlling a dog without vaccines. I do find probable cause, and Mr. Sierra, your private counsel, Mr. Jelen, is present here in the courtroom with me.
So I represent him on the VOPs. Judge Colra is not here today, apparently. He'll be up tomorrow with Judge Colra, Victor. You understand? You understand? Even if Coughlin? If Judge Coughlin wanted to release you, she couldn't. That wouldn't be appropriate. It's got to be for Judge Colra tomorrow. You understand that? You understand?
Press the button, Mr.
Oh, okay.
Sierra. It's the mic, yep.
Yes.
All right. So in any event, Judge, I don't represent him on the dog cases, but since I am here for the probable cause component, I do understand it's a capious. But
Yes.
I'd ask you to review those dog cases. I don't see how they can show there was no vaccine unless they got blood test or DNA test or something.
Well, Mr. Jelen, I understand what you're saying, but I believe I was the division judge that issued those capiouses, so they're going to stand at this time.
All right. Thank you very much. I'll see
Okay?
you tomorrow,
All right.
Victor. All right.
Mr. Sierra, you'll see your division judge tomorrow. Thank you.
All right.
Okay. I don't have any other sign-ins at this time, so I'm going to start going down our list. Once again, we'll be hearing cases for Maine, Conti, and Paul Ryan. So if we have somebody from North Broward, just let me know and we'll put it on recall. All right, first will be Sarah Jameson. Okay,
I believe North Broward.
thank you. This is, North Broward ones? Well, there's not just one. Okay. Nancy Lesser is also an MO case, so we're gonna have to wait on council to get here. Maria Trave, or Trave,
Medical reset.
thank you.
Maria Trave on page 3.
Rose Reinshuttle. Okay. Billy Santesteban,
Medical reset.
thank you. Connie Buchanan,
North Broward.
Sarah Salinas,
North Broward.
Kenneth Brown, thank you.
Please approach the judge here, ma'am.
Thank you. Good morning, Mr. Brown.
Good morning, Your Honor.
Mr. Brown, you're before the court this morning on one charge for domestic battery by strangulation. I find probable cause, and I'll hear from the parties. Mr. Romero, would you like to go first?
I'm ready.
Oh, you ready?
Yeah.
Okay.
I'm good. Thank you. Your Honor, I see a 2009 battery arrest that was dropped. Everything else was DWLS's. I'm requesting a $7,500 bond, no victim contact, primarily based on the level of violence and the allegations that it is alleged, while still in the close proximity of time, that Mr. Brown strangled the victim on 2 occasions. Nothing further.
Romero?
Judge, in speaking with Mr. Brown, unfortunately, he's not going to be able to afford to post that monetary bond. What he advised me, he's self-employed, he does DoorDash. That fluctuates, but on a great week, he can make about $300. Now, my understanding is the alleged victim has basically moved out. They were residing at his mom's house. That's where he's going to continue to reside. His mom's the only person that can help post his monetary bond, and my understanding is that her financial resources are quite limited, if anything at all. My understanding that she collects disability. Judge, Mr. Brown is looking forward to contesting these allegations. He will be coming back to court, but he simply can't afford what the state is asking for. We're asking something that maybe his mom can afford using the services of bondsman. We're requesting a $1,000 bond on his behalf.
And I would add, Judge, that for the extent in which the victim claims to have been strangled on 2 separate occasions, there were no marks or bruises around her neck.
Bond will be set at $4,000. There will also be an order of no victim contact. Mr. Brown, so that you understand, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, Your Honor.
Thank you. Bolden Johnson,
Mr. Johnson, come on up, please.
good morning, Mr. Johnson. Mr. Johnson, you're before the court this morning on one charge for aggravated assault with a deadly weapon, domestic violence. I find probable cause, and I'll hear from the parties.
Your Honor, the state is going to be requesting a $10,000 bond, pretrial release of the GPS monitor, no victim contact. First, I would note, it appears Mr. Johnson has a pending possession of methamphetamine. Additionally, 2014, he was convicted of aggravated battery, great bodily harm. That was against a different woman. He was qualified as a habitual offender in that case. 2002, possession of cocaine with intent to sell, distribute. Excuse me. within 1,000 feet of a place of worship, 3-year state prison. Also, a previous shooting at or throwing a deadly missile arrest that was dropped. Your Honor, our office also had contact with the victim. She advised that she has safety concerns. She believes, based on her experience with him, that he will violate any no-contact order this court issues. She has also advised our court there has been previous violence that appears has been undocumented. And lastly, I would just note, and I know the court's aware of this in the report, it does appear that children were in the home at the time this incident occurred.
Mr. Romero?
Judge, Mr. Johnson is obviously, he's disputing these allegations. Hold on. He believes the alleged victim is motivated by ulterior motives. But having said that, I did advise Mr. Johnson today is not his trial day. His attorney will be contacting the case file and going into those issues. Having said that, Judge, he's been here his whole entire life. He's 39 years old. He's working. He's been working, putting things together for boat shows. He's been doing that for about 6 years now. On a great week, he can make up to about $400 a week. Now, he does understand, I did advise him because of the domestic situation, there's going to be no contact. He lives with the alleged victim, but he's going to be moving out. He's going to be residing with his father, separate and apart from the alleged victim. Now, he lives here locally in Hollywood. My understanding, he does landscaping for a living, so he's not going to be able to post what the state has asked for. We're going to be requesting a $2,500 bond on his behalf, and considering the totality of the circumstance what the state has advised us, we wouldn't object if the court also wanted to place Mr. Johnson on standard pretrial release, Judge.
All right, I'm very concerned with the allegations that have been made in the probable cause affidavit, including multiple threats to kill both the alleged victim and the children that reside within the house. I understand what Mr. Romero has said has been represented to him by Mr. Olden regarding, potential ulterior motives, but there are observations made by law enforcement that are noted in the probable cause affidavit that do give me some concern as to whether there are perhaps some underlying issues going on here with Mr. Johnson that the court's not aware of or isn't before the court at this time. Based on everything that I'm seeing, I'm going to set the bond at $7,500. If Mr. Johnson does post that monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact. Since he will be on the level 2 GPS monitor, Mr. Johnson needs to be aware that will include a 500-foot stay away from the victim in this case. Mr. Johnson, so that you understand, in addition to that 500-foot stay away, which means no being within 500 feet of the alleged victim, there will also be no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am.
Thank you.
And Your Honor, I'm sorry, one last thing, and I apologize if the court already ordered this, but because, as you mentioned, there were also threats made against the children, I would ask that there be a court order of no contact with any children he shares with this alleged victim at this time.
Are the children that reside in the residence shared children between the two individuals?
I believe he just nodded in the affirmative.
Judge, I'm going to ask, pursuant to Mr. Johnson's request, the alleged, the kids are not the alleged victims on this offense. My understanding, speaking with Mr. Johnson, is the children's mother works. They have an arrangement while she works. Basically, Mr. Johnson, he's the one that takes care of the kids. Nobody else is going to be able to take care of the kids. He's asking for the court. He has no problem with the no contact order regarding the alleged victim, but he's asking the court not to impose a no contact order on the kids.
Okay, well, at this time, as I said before, I am concerned with the allegations in the probable cause affidavit. Specifically, there are allegations that he continuously stated he was going to kill both the alleged victim and the kids. That apparently was allegedly said multiple times throughout the duration of this incident. So based on those allegations, the no contact order will include the minor children at this time. very much. Okay, thank you. Cases that were in my stack, so I'm going to go to those now. Let's see if we can address some of them. First will be Rose Rheinshuttle. North Broward, do you have Miss Rose Rheinshuttle?
It's up, they're just, did anybody let them down?
One of the deputies at North Broward come on the screen just so I can confirm that you are able to hear and see us here at the courthouse.
She did not. It's quite intentional.
Are they able to hear us though? Okay, all right. Okay, so I'll leave the North Broward cases to the side and we'll come back to them when they're ready. Next up will be Gregory Wilson.
Let's see.
Mr. Wilson is approaching, Judge. You see our man. Come on up, sir.
Thank you. Good morning, Mr. Wilson. Mr. Wilson, you are before the court this morning on one charge for domestic battery by strangulation. I find probable cause, and I'll hear from the parties.
The state would be requesting a $7,500 bond, no victim contact, based on the allegations. Mr. Wilson's criminal history includes, as far as Broward, 2011 possession of cocaine, 2010 possession of cocaine, year in a day state prison, 09 possession of cocaine, year in a day state prison, 07 an arrest for aggravated assault, that was dropped. Another arrest for aggravated assault in 07, that was dropped. Prior to that, mostly cocaine charges, Your Honor. I see a battery that was dropped in the early 90s, a burglary dwelling that he went to prison on, but those are, nothing else to provide the court.
Carol?
Judge, Mr. Wilson, needless to say, after this argument, no longer lives at those premises right now. Basically, he's going to be homeless if he gets released. Now, he doesn't work, he gets disability, he gets approximately $700 a month, so there's no way he's going to be able to afford the $7,500 bond, which the state is requesting for at this time. Now, as you heard, Judge, he does have a criminal history. However, it's kind of dated. I believe the last one the state read off was back in 2011, so he's been about 9 years clean. Now, he's been here his whole entire life. He's 53 years old. He's very much contesting the facts on the probable cause affidavit. We're going to be asking for the court to consider a $3,000 bond on Mr. Wilson's behalf, Judge.
All right. Bond will be set at $4,000. There will be an order of no victim contact. Mr. Wilson, no victim contact, so that you understand, means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes. Judge, I believe Mr. Wilson wants to talk to and address the court. I just advise him do not talk about the facts of the case.
Okay, Judge, I have a lawn service trailer fully equipped. I have a truck and a car, 2 scooters. All my belongings are at that house.
Okay.
So Judge, based on that information, would the court allow Mr. Wilson to go back one time with law enforcement to retrieve his property?
I will allow
mean,
him, hold on, Mr. Wilson. I will allow him to return one time, but it must be with local law enforcement in order to retrieve the personal property.
I mean, this is what it's all about. She's trying to take my possessions.
Okay, Mr. Wilson, don't talk about the facts of the case. You understand what I've said about returning with law enforcement?
Yeah, I heard what you said.
All right, thank you. Fernando Ventura Madera.
He's approaching, Judge. He's here with me.
Thank you. Good morning, Mr. Ventura.
Good morning, Your Honor.
Mr. Ventura, you're before the court on 2 charges. 1 is touch or strike battery, domestic violence. 2 is criminal mischief, over $1,000. I find probable cause, and I'll hear from the parties.
Your Honor, I see no history. The state is requesting a $1,500 bond on count 1, no victim contact.
Aaron?
Judge, that's reasonable. Nothing to add from the defense.
All right, thank you. Bond will be set at $1,500 on count 1. The standard bond will remain in place on count 2. There will be an order of no victim contact. Mr. Romero, I expect that you will probably talk to him about this, but Mr. Ventura, if you do reside at the residence with the alleged victims, you will have to find someplace else to stay for the time being, because no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Understood, Your Honor.
Thank you. Shane Morris.
Judge, I haven't had an opportunity to speak to him. If we could put him on a recall, Judge.
All right, just let me know when he's ready. Tony Clark.
He's approaching, Judge. He's here with me.
Thank you.
Come on up, sir.
Good morning, Mr. Clark.
Good morning.
Mr. Clark, here before the court on 2 charges. 1 is touch or strike battery, dating violence. 2 is a parole violation, which has a no bond hold. I find probable cause. I'll hear from the parties on count 1.
Your Honor, considering the fact that considering that Mr. Clark is on parole for a violent offense out of another state,
Yes.
the state would be requesting a $2,500 bond, no victim contact.
We were going to be requesting on this misdemeanor offense, Judge, considering the parole violation, $1,000 bond.
Bond will be set at $1,500. There will be an order of no victim contact. Mr. Clark, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes.
Thank you.
Judge, if for some reason Mr. Clark deals with the parole hold, Judge, can he go back one time with law enforcement to retrieve his property?
As long as it's with local law enforcement, yes. One time.
North Broward's ready, Judge.
Thank you. Back to some of our North Broward cases. First up will be Rose Rhine Shuttle.
They sent some people back to their cells because of the delay.
Well, if the deputy could just let me know if they're there or not. Deputy, I gotta know who's there or not. We gotta keep moving.
Okay, she's actually on her way back, Ryan Shuttle and
Okay.
Jameson.
Okay, I'll come back to her. So next will be Connie Buchanan.
Buchanan is actual refusal.
All right, so we'll reset her. Sarah Salinas,
Yes, we do have her here.
thank you.
North Broward Drive.
Thank you. Good morning, Ms. Salinas. You're before the court this morning on an out-of-state felony hold. I find probable cause. Ms. Salinas, this is a no bond hold out of the state of Texas, which means that you'll be going before the extradition judge shortly so that you can address how that matter is going to be handled. Good luck. Mark Orcand.
Done.
I believe Mr. Forcan is on loan, Your Honor.
Is he still on medical loan? Okay. David Cicchini. Thank you. Good morning, Mr. Cicchini. You're before the court on a traffic capias. This is a charge for operating without a valid license. I find probable cause, and I'll hear from the parties.
Judge, in speaking with Mr. Caccini, he wishes to resolve this matter. We wanted to see if the state had a plea offer for him.
Yes, Judge, it is withhold court costs.
Withholding court costs.
Yes, Judge.
He wishes to accept the state's offer, Judge.
Thank you. Mr. Cicchini, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. Mr. Cicchini, do you understand everything that's been discussed so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
Thank you, Mr. Cicchini. I accept your plea and find that it's freely and voluntarily given. Once again, your sentence will be a withhold of adjudication plus court costs. Good luck to you. Jericho Morlock.
He's approaching, Judge.
Thank you. Good morning, Mr. Morlock.
Morning, Your Honor.
You're before the court this morning on a misdemeanor capias. This relates to a charge for battery. I find probable cause, and I'll hear from the parties.
Judge, we're going to be asking if the court would consider a straight ROR. As you can see, this offense today, I believe it's a case number, it's a 2018 case. He was state sentenced. He's been in custody for about 18 months. His EOS is actually today. So this would be the only thing holding him. So based on that, this is a misdemeanor offense. I'm asking if the court will consider an ROR, or in the alternative, just leave the bond in place.
State would request, yes, Your Honor. It appears that Mr. Morlock got sentenced to state prison on a violation of probation after this failure to appear. Considering it's a battery, I would ask Your Honor to allow him to go before a judge in Central unless he posts bond, and so the case can proceed.
All right, then I'll leave the bond in place, and there will be an order of no victim contact. Mr. Morlock, one moment. I just have to tell you, because I'm imposing the no victim contact order, that means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, Your Honor.
Okay, thank you. Good luck.
North Broward has the individuals we were looking for earlier, Judge.
Okay. I'll go back to Rose Rhine Shuttle.
North Broward Drive.
Thank you. Morning, Ms. Ryan Shuttle.
Good morning.
Ms. Ryan Shuttle, you're before the court on 5 charges. 1 is for trafficking methamphetamine, 28 grams less than 200 grams. 2, possession of fentanyl. 3 is for disobeying a stop sign, that is not for magistrate. 4 is for disobeying a red light, that is not for magistrate. 5 is a felony probation violation with a no bond hold that has a hearing set before the division judge tomorrow morning. I find probable cause for these charges, and I will hear from the parties on counts 1 and 2 if they wish
Your
to
Honor,
be
I'd ask that
heard.
the court keep the bond on count 1 in place. This is a 3-year minimum mandatory sentence. She also had a weight well over the minimum standard of 28 grams. She has a no bond hold for a violation of probation, and on top of that grand theft, she has another pending grand theft that she's out on bond, and this would obviously be a violation of her bond conditions in that case as well.
Judge, I realize she has a no bond hold, but $100,000 is something that she's just not going to be able to afford to post. I'd ask the court to consider a $25,000 bond on count 1.
All right, in this case, it looks like we're dealing with a total of just under 100 grams of methamphetamine as to count 1. That's obviously well above the 28-gram bottom line on that charge. At this time, I'm going to leave the standard bonds in place. Ms. Ryan Shuttle, you'll be seeing your division judge tomorrow morning. Thank you. Okay. As far as Jameson goes, that's a municipal ordinance case, and I'm waiting on the city attorney to come back on that. So I'm going to keep going down our paperwork, and I'll call it back as soon as that city attorney comes back in. Next will be Jethro Nix. Thank you. Good morning, Mr. Nix. You're before the court on a misdemeanor capias. This relates to a charge for battery. I find probable cause, and I'll hear from the parties.
Nothing from the state, Your Honor.
Judge, Mr. Nix is asking if the state has a plea offer for him today.
I do not, Your Honor. The victim would have the right to be advised and present under Marcy's law.
On the capias, I'm seeing that this is per an order signed by Judge Hurley. Is there a separate order that I don't have a copy of?
No, there may be, Your Honor. It's an issue summons capias. I can tell you, this is not a situation involving two strangers. They are known to one another, according to the alleged victim. This happened at Broward Outreach. The alleged victim did not show, according to her, did not show romantic interest in Mr. Nix. In response to that, he allegedly slapped the left side of her face. There has been contact with the alleged victim, and she advised that she is in fear of Mr. Nix.
Judge, in speaking to Mr. Nix, I believe this incident happened, like as the state said, about 5 months ago. I don't know if that fear at this time is reasonable, considering they've had no further contact or there's been further incidents since that date. Mr. Nix would adhere to a court order as far as no contact as evidenced by his behavior. He's had no sort of contact. My understanding, Judge, unfortunately, he's homeless. He gets disability. There's no way he's going to be able to afford the $1,500 bond. So we're asking if the court would consider an ROR on Mr. Nix's behalf.
This is, Your Honor, is the state and law enforcement tried to avoid a situation with him not having to be arrested by treating this as an issue summons. The problem is it couldn't be served because there's nowhere to serve him with it. And ultimately, the only way to get him before the court was to arrest him. And that's the issue. And I don't know that there's anything, Mr. Romero is advising the court of that can resolve that matter. And it is true. It did happen several months ago, which is why it is the state's hope to. And I would note, Your Honor, he was arrested in Leon County. So he wasn't even down here still.
And Judge, my other thing, he will be coming back to court, but my understanding is Mr. Nix, from what he just advised me, he was actually extradited here. He's no longer living in Broward County, so he doesn't present a danger to the alleged victim who resides here in Broward County. He's not gonna have any contact, but he will be sure to come to appear at court. So that's why we're asking what we're asking for, Judge.
Okay. At this time, since this is a capias that was issued, Judge Hurley is the one that set the bond in this case. I'm gonna leave the bond in place at this time. Mr. Nix can go before his division judge, yes.
Since this is the first time that Mr. Nix is appearing before a judge, only other request I would make is if you could order no victim contact with Donalyn Williams.
Correct order, which shouldn't be an issue for Mr. Nix. Mr. Nix, so that you understand, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am, I be having no contact with her no way.
Okay, thank you. Mr. Romero, are you ready on Shane Morris yet, or you still need time?
No, I still need a little bit of time.
Okay, that's fine. Lamar Smith.
Mr. Smith, come on up, please. He's approaching, Judge.
Thank you. Good morning, Mr. Smith. Mr. Smith, you're before the court on one charge of first-degree petty theft. I find probable cause, and I'll hear from the parties.
Oh, Judge, in speaking with Mr. Smith, he wishes to resolve this matter. We want to know if the state has a plea offer for him.
I do. It's withhold court cost no return.
Withhold court costs, no return.
Judge, he wishes to accept the state's offer.
All right, Mr. Smith, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. And Mr. Smith, do you understand everything that's been discussed so far today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Mr. Smith, your sentence, once again, will be a withhold of adjudication plus court costs. There will also be a no return order to the Walmart that's at issue in this case. Do you understand that?
Yes.
Okay.
I understand.
Thank you. Good luck.
Judge, we're ready to proceed on Mr. Morris.
Okay, he'll be next then. Good morning, Mr. Morris.
Good morning, Judge.
Mr. Morris, you're before the court on one charge for battery on a person 65 years of age or older. I find probable cause, and I will hear from the parties.
Your Honor, I'm going to be requesting a $10,000 bond and no victim contact. One, based on the level of violence, punching the victim in the face. I'm concerned about how this whole situation began, involving children that were also present when this occurred. Lastly, and I think it's extremely relevant considering it does mention that Mr. Morris had just gotten out of being in a rehab program for 2 weeks. Mr. Morris has a pending felony right now for possession of methamphetamine and drug paraphernalia. He's out on that case. He has criminal mischief and grand theft prior to that, but frankly, They're so dated, I don't think it's necessarily relevant for the court's consideration.
Mr. Romero?
Judge, as you heard, Mr. Morris was at a treatment facility, I believe Faith Farm. He's not working, so financially he is indigent. He's 32 years old, been here his whole life. My understanding, Judge, he has priors, but I believe this is his first time being arrested on a domestic situation. We're going to be requesting, because of his financial circumstances, we're going to be requesting a $2,000 bond on Mr. Morris's behalf.
I understand that his history is somewhat limited when it comes to domestic situations, but the allegations in the probable cause affidavit are very serious. Based on what I'm seeing, the information that's been provided, bond is going to be set at $7,500. There will also be a no victim contact order. The court is also going to impose a no return order to the residence that this occurred at. Mr. Morris, so that you understand, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, Your Honor.
All right, the no return order also means that you are not to return to the residence that this occurred at until further order of the court. Do you understand that?
Yes, Your Honor.
All right, thank you. Do we know which facility Dimitri Johnson is at?
He's here at Main, Judge.
Okay.
Mr. Johnson, come on up, please.
Thank you. Good morning, Mr. Johnson. Mr. Johnson, you're before the court this morning on one charge for trespassing on property, not a structure or conveyance. I find probable cause for this charge, and I will hear from the parties.
Judge, at this time, Mr. Johnson wishes to resolve this matter. We want to see if the state had a plea offer for him.
The state does have a plea offer. It's adjudication 7 days in county jail, based not only on the allegations in this case, but, and I'm sure Mr. Romero remembers, Your Honor, Mr. Johnson appeared before you 2 days ago on a theft that he pled out. Previous to that, he was arrested January 3rd in Broward for a theft, resisting without violence, and a trespass that he got time served. I believe he has open cases in Dade, or at least one open case in Dade, for a trespass from January 24th.
Judge, my understanding, yes, he was here 2 days ago. I didn't remember. I spoke with Mr. Johnson right now. I believe he was here on a theft-related offense out of Dillard's, and I believe the trespass was in reference to the Dillard's location. I do not believe this had anything to do with this particular location. Judge, considering this is, and I could be mistaken, but considering this is the first trespass that appears before you regarding this location, Judge, 7 days, I believe, is excessive, considering if he had $25, he could simply pay the bond and have his day in court. Would the court consider getting involved in plea negotiations and extending an offer of adjudication time served?
I just want to note, because I don't want to embarrass Mr. Johnson, but the court is familiar what the alleged conduct on Broward College campus was. If Mr. Romero would like to know,
We don't need to go into it. I'm not going to take any plea offer at this time. I'm going to leave the $25 bond in place. There is also going to be a no return order. I believe there is already a trespass that's been issued by Broward College that applies to all Broward College campuses. So it should go without saying, but I'm going to say it anyway. There's a no return order. Mr. Johnson, that means that you are not to return to this property until further order of the court. Do you understand that, sir?
Yes, ma'am.
Thank you. Jamaris Coldman.
Approaching, Judge.
Thank you. Good morning, Mr. Coleman.
Good morning.
Mr. Coleman, you're before the court on a charge for disorderly conduct. I find probable cause. I'll hear from the parties.
Judge, Mr. Coleman wishes to resolve this. We want to know if the state has a plea offer for him.
Okay.
Your Honor, offered via withhold court cost, no return. Yes, Judge.
That's to the shopping center, right? Because I don't think this was at a specific.
It's just noting the incident location, 1750 Sheridan Street.
Okay.
Judge, he wishes to accept the state's offer.
All right, Mr. Coleman, please raise your right hand. Do you swear or affirm to tell the truth? Thank you. You can put your hand down. And Mr. Coleman, do you understand everything that's been discussed here so far today? Is anyone forcing you to resolve your case?
Is anyone forcing you to resolve your case? Then let the judge know that.
No.
Mr. Coleman, are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Once again, Mr. Coleman, your sentence will be a withhold of adjudication plus court costs, and there will be a no return order to the place of incident. Do you understand that?
Yes.
All right, thank you. Good luck. Stephen Fury.
North Briar, Your Honor.
Thank you. Good morning, Mr. Fury.
Morning, ma'am.
Mr. Fury, you're before the court on 2 charges. Charge 1 is for pedestrian failing to use a crosswalk. That charge is not for magistrate. 2 is for resisting an officer or obstructing without violence. I find probable cause, and I will hear from the parties.
Does the state have an offer?
Yes, it'd be a withhold court cost.
Mr. Fury, would you like to accept that offer? It's no conviction on your record. The case would be over this morning. I don't think there's anything else holding you, so you would get out of jail today, and you'll have 6 months to pay the court costs.
Yeah, no contest, sir. It was a construction zone. I didn't understand I shouldn't cross there.
That's all right. That's not, you're not being magistrated on that, just on the resisting arrest without violence.
Okay.
Okay, so Mr. Fury, if you would like to accept that offer, I'm going to ask you a few questions, and then we'll be done, okay?
Yes, ma'am.
Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and you can put your hand down. And Mr. Fury, do you understand everything that we've discussed so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, I understand completely, ma'am.
Okay. Do you understand that you have the right to trial, but you're waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
I understand, ma'am.
And Mr. Fury, what plea do you wish to enter, guilty or no contest?
No contest, ma'am.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. All right, good luck to you, sir.
Thank you.
You're welcome. Fitzgerald Noel.
Judge.
Thank you. Good morning, Mr. Noel.
Morning, Your Honor.
Mr. Noel, you're before the court on 2 charges. 1 is for first-degree petty theft. 2 is a traffic capias that relates to a charge for operating without a valid license. I will hear from the parties.
Judge, and speaking Mr. Noel, he wishes to resolve both matters today.
Your Honor, on the theft, it would be a withhold, court cost, no return. Excuse me. On the operating without, it would be an adjudication time served.
Judge, he wishes to accept the state's offer.
All right, Mr. Noel, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. You can put your hand down. And Mr. Noel, do you understand everything we've discussed here today?
I fully understand.
Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with your attorney?
no,
Do you understand that you have the right to trial, but you're waiving that right by taking a plea?
understand.
Have you ever been treated for mental or emotional illness?
No,
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
I understand.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Mr. Noel, your sentence as to charge 1 will be a withhold of adjudication plus court costs. There will also be a no return to the JCPenney where this allegedly occurred. And your sentence as to count 2 will be an adjudication time served. Good luck to you, sir. Next will be Brandon Lorama.
Please remain.
Thank you. Good morning, Mr. Lorama.
Good morning.
You're before the court this morning on a traffic capias. This is a charge for operating without a valid license. I find probable cause, and I'll hear from the... Oh, I'm being advised by confinement his bond has been posted. Okay? All right. David Blue.
North Broward, I believe, Judge.
Yes, medical reset, Your Honor.
Okay. All right, thank you. Enrique Vargas Torres. Oh, excuse me, that's an MO. That's an MO case. I'll have to come back to him. I'm sorry? Yes. Oh, yes. Thomas Morin. Thank you. Good morning, Mr. Morin.
Good morning.
Mr. Morin, you're before the court on a charge for touch or strike battery. I believe it was yesterday. This court found probable cause, and we've set the hearing this morning to discuss bond. So I will hear the parties' recommendations.
See at least once he's been out pre-trial. Tell me if there's ever been any issues with him. Your Honor, I'm asking. Yeah, he had a and he has a lengthy history. Mr. Morin's been through this division multiple times. I'm asking that the court take no action at this time.
Judge, I don't think Mr. Morin's going to be able to afford a $1,000 bond in this case, or any other kind of monetary bond. The battery here is not actually striking someone, but spitting at someone, which I'm not saying that's not a battery, but I think it's a different classification as to punching someone. I'd ask the court to consider pretrial release for Mr. Moran.
Based on the information that pretrial has given me, I'm not willing to release him to pretrial at this time. I will leave the standard bond in place, and if Mr. Moran doesn't post his bond, then he'll be going before his division judge. All right, thank you, Mr. Moran.
Again.
Gabor Green.
Judge, what page is Mr. Green on? Oh,
Page
yeah.
15.
Gibber Green, come on. He's approaching, Judge. It's your main.
Green. Mr. Green, you're before the court on 2 charges. 1 is for second-degree petty theft, second offense. 2 is for possession or use of drug paraphernalia. I find probable cause, and I'll hear from the parties.
Judge, Mr. Green wishes to resolve this matter today.
Offer be withhold court cost on both counts, no return.
Wishes to accept the state's offer.
All right. Mr. Green, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. Mr. Green, do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yeah.
Have you ever been treated for mental or emotional illness? Just say
No.
it. Okay. And do you understand that if you're not a U.S. citizen, taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, sir? Guilty or no contest?
Calvin Jackson.
Okay, I accept your plea and find that it's freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. There will also be a no return order to the Home Depot where this allegedly occurred at. Do you understand that, sir?
Yes, ma'am.
Thank you. Good luck. Carlos Jaregui.
I'm advised that he's in court, Judge.
Okay. Yes.
No, I don't.
All right, then we'll find probable cause as to the charge. And if he's in court before his division judge on this morning, then do we have any objections to me just leaving the standard bond in place on the sheet?
No, Your Honor.
Thank you. Anthony James.
He refused.
Your Honor, and I don't know if Mr. Reedy will have any objections. It would appear Mr. James has about 7 other cases, all the same MO. Going into a Walgreens, going behind the counter, stealing cigarettes, either threatening, sometimes threatening the clerks. He has 7 other, he's being held no bond on a strong arm robbery. On the 7 other burglary and/or strong-arm robbery cases, bond has been set on at $5,000 on each of them. I was just going to be asking for the same bonds on the strong-arm robbery and the burglary on these cases.
Well, I know Mr. James apparently really likes Newport cigarettes,
Yes. From Walgreens.
because that seems to be the item that gets stolen every time. No, I don't mind, Judge. Since he decided not to join us, that's fine.
Okay, then I'll make a probable cause finding, and bond on counts 12 and 13 will be set at $5,000 to be consistent with the other charges. Thank you. Juan Gaviria. Thank you. Good morning, Mr. Gaviria.
Good morning, Judge.
Mr. Gaviria, you're before the court on an ad charge this morning. This charge is for false ownership information provided for pawn items less than $300. I find probable cause. I'll hear from the parties.
Nothing for the state, Judge.
Okay, Mr. Romero?
Judge, nothing from the defense.
Okay, in light of that, the standard bond will remain in place on this charge. Thank you. Derek Cooper?
North Broward.
North Broward, gentlemen.
Thank you.
You're welcome.
Good morning, Mr. Cooper. Mr. Cooper, you're before the court this morning on charge 1, possession or use of drug paraphernalia, 2, bike regulation violation, 3 and 4 are both felony probation violations with no bond holds, which have a hearing set before the division judge tomorrow morning. I will hear from the parties on count 1 if they wish to be heard.
No, there's nothing to add, Judge. He's got no bond holds.
Okay, all right. In light of that, for the record, I find probable cause. And Mr. Cooper, you'll be seeing your division judge tomorrow morning. Thank you. Devin Blaze.
North Broward.
Thank you. Good morning, Mr. Blaze.
Good morning, Your Honor.
Mr. Blaze, you're before the court this morning on charge 1, possession with intent to sell, manufacture, or deliver cocaine. Count 2, possession of cocaine 20 grams or less. 3, possession or use of drug paraphernalia. 4, operating without a valid driver's license. 5, driving while license suspended, third or subsequent offense. 6 is another driving with license suspended. 7 is attaching a registration or license plate not assigned to the vehicle. I will hear from the parties.
Judge, I'm trying to reach some family members of Mr. Blaze's. I have not had any success as of yet. But Mr. Blaze, did you tell me that your family had hired a lawyer for you?
No, not my family, but the guy that I was staying with is like a brother to me, and he has a lawyer. He was gonna bond me out when he gets bonded out, and he was gonna have his lawyer present me.
Okay.
But my family, I don't really have no family, so really, my mom's in Chicago and she's on drugs, and my grandfather really don't care.
All right, sir. All right. Judge, as to count 1, I'd ask the court to consider a $1,500 bond.
Your Honor, frankly, if the court is inclined to reduce some of the other bonds, I really wouldn't have an objection. To me, they're less serious, but I think the most serious offense, the second-degree felony, $2,500 bond should be kept in place.
All right. Then I'd ask for an ROR on counts 2 through 7.
Mr. Linder, any objection to that?
No, Judge.
All right, then the standard bond will remain in place on charge 1, and 2 through 7 will each be an ROR. All right. Thank you. Good luck, Mr. Blaze.
Thank you, Your Honor.
I have private counsel signed in on Jeffrey Thomas's case on page 23. I just need to pull the paperwork.
Judge, did you say he has private counsel?
Yes, I believe it's his sister. Is that correct? Okay. Yes, his sister is his private counsel.
Oh, that's your turn.
All right. Good morning, Mr. Thomas. You're before the court this morning on one charge for sexual battery, victim between 12 and 18 years of age by a person 18 years of age or older. I find probable cause, and once again, as I stated, your private counsel is present in the courtroom, so I will hear from the parties at this time.
Your Honor, based on the nature of the allegations in the arrest warrant and affidavit signed by Judge Orlando, considering this is a first-degree felony, I'm asking that the court keep the bond that Judge Orlando set in place and issue an order of no victim contact.
Spoke with the detective on this case several months ago, and it was my understanding that this person was over the age of 18 and was just saying that she was heavily intoxicated, that was the issue at hand. So I'm not quite sure how it's become a person between the ages of 12 and 18.
Yeah,
Is it the finding sheet is incorrect? So the correct charge should be sexual battery, great force not used.
against a victim over 18. That being said, Your Honor, it is still a first-degree felony.
All right, well, hold on, let me just make sure. I want to correct the finding sheet. So for confinement purposes, I'm just going to write in the corrected one that's on the booking sheet. So, all right, let me just, give me 1 moment. Let me just write this in. I've made the correction to the finding sheet. So let's continue.
I apologize, it's a second-degree felony.
Okay.
Sorry, what was the bond you were requesting?
I'm requesting that the bond that Judge Orlando set be kept in place.
Honor, Mr. Thomas is a high school student. I believe this occurred as a result of miscommunication. If you did, well, I'm not sure if it's, I'm just seeing this for the first time, but Mr. Thomas had consensual sex with the victim. According to her statements, she was intoxicated. However, she did text Mr. Thomas afterwards, hey, what's up? And she was upset because he basically didn't want to pursue a relationship with her. At this point, he is a high school
Your Honor,
student.
I'm objecting to those representations as they are not before the court.
Stop you, counsel, for a minute. And I'm only saying this because I understand there's a personal relationship there. And you just told me that this is the first time that you're seeing this affidavit. Would you like to take a few minutes to read through it before you continue?
Yes, Your Honor.
What I'll do is I'll go to our next case, and then we'll come back to Mr. Thomas's case in just a moment. All right, I'm just going to put him on recall. Next will be Stanley Paul. Good morning, Mr. Paul. Mr. Paul, you're before the court this morning on count 1, resisting an officer, obstructing with violence. 2, leaving the scene of a crash involving damage to property. 3, fleeing or attempting to elude law enforcement. 4, reckless driving, first offense. 5, driving with a suspended or revoked license. 6, disobeying or avoiding a traffic device. And 7 is for unlawful speed. That is not for magistrate. I find probable cause, and I will hear from the parties.
Your Honor, I'm checking to see if there's any history, if Mr. Romero wants to proceed.
Judge, we're going to be requesting a $1,000 bond on Mr. Paul's behalf on count 1, the resisting with violence, and more importantly, we're going to be asking for a photo order so we can photograph the injuries that Mr. Paul sustained.
Thank you.
Your Honor,
Yes.
on count 1, I'm going to be requesting that I'm fine with $1,000 on count 1. That being said, I am going to be asking for a bond increase on count 3. I do believe the factual allegations are quite aggravating, that should necessitate an increase over the convenience bond. Considering the allegations that he was driving 130 miles per hour in Dade County while fleeing from law enforcement, that he traveled into Broward County and then ran a red light, causing a crash that injured one of the driver of the other vehicle. He then fled from that vehicle along with all the other occupants in his vehicle. I think just based on the driving pattern, a bond increase is necessary. I'd be asking for a $5,000 bond. Yes, ma'am.
Judge, that's something Mr. Paul is not going to be able to afford. From what he advised me, my understanding is parents know he's here. If the bond were set and left at the standard bonds currently, they would have been in a position to post his bond. However, the state is asking for an increase to $5,000 on 3. If the court is inclined to do that, Judge, I'm going to ask for an ROR on counts 2, 4, and 5. Right now, Judge, unfortunately, Mr. Paul, he's not working. He's looking for work. His parents are helping him financially, but they have limited funds. Judge, he's been here his whole life. He's 23 years old. Judge, he's not going to be able to afford that much.
All right. I will sign the photo order that was requested, just for the record. The bond on count 1 will be set at $1,000. The bond on count 3 will be increased to $5,000. And per Mr. Romero's request, counts 2, 4, and 5 will each be an ROR. Back to Mr. Jeffrey Thomas's case. His counsel is ready. Okay. All right, counsel, have you had an opportunity to review the affidavit? Okay, so please continue.
Your Honor, it's
Just speak
unfortunate because I did speak with the
microphone so we can
I
hear
did
you.
speak with the officer when this incident occurred, and a lot was left out of this affidavit, so I'm not really sure why that was. But like I said, he is a high school student. He had just turned 18 right when this incident did occur. I believe the victim was well over 18, and it seems as though it was a retaliation thing as far as why this was brought about. His parents do not have money. They're not rich. We're just asking that the bond not be $25,000 because he's a high school student. He's not going to run anywhere. He doesn't have any money to go anywhere.
Recommendation.
I would ask for $5,000, Your Honor.
As I would note, and that does mention that the detective did reach out to counsel multiple times. Voicemails and emails that were not responded to, it would appear. Also, I would note, Your Honor, if the alleged victim's motivation was merely one of retaliation, then certainly I would have imagined there'd be an embellishment of some of the allegations But she denied that he threatened her, used a weapon. I'm not going to go into the detail, but other comments she made. Certainly, if she was making this up, there were more incriminating things she could have mentioned about Mr. Thomas.
Said he's a high school student, Your Honor. I believe the victim is way older than him, if I remember correctly. I'm not quite sure. I don't remember exactly what her birth date was. If anything, I feel as though she took advantage of him at the time. As far as the detective reaching out to me, I responded to the detective several times. The detective told me if they wanted to collect his DNA, they would pick him up to do so. So she was free to do so. I'm not sure what else I needed to do at that point in time. We spoke with her. We did everything that they asked us to do. They got a warrant for DNA, and they said they would pick him up. That is what I thought this was about, picking him up for his DNA. Besides that, I'm not sure what else they were calling me for. I didn't receive any voicemails about anything else. We met with them in person about the actual incident that happened.
High school does he go to?
Miami Norland Senior High.
State does he have any prior? Set the bond at $10,000. There will be an order of no victim contact. Mr. Thomas, so that you understand, no victim contact means you are not to be in the same place at the same time as the alleged victim. Additionally, there are to be no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am.
Thank you.
$10,000.
All right. Okay. All right, we're gonna go over to our city cases. We have council present. We've got a number of them, so. Good morning, council. All right. Howard, on page 1, Sarah Jameson. Thank you.
Davika Carr on her behalf, covering for Mr. Stephen Sheet.
Thank you, Ms. Carr. Good morning, Ms. Jameson.
Good morning.
Ms. Jameson, you're before the court this morning on a misdemeanor capias. This is a municipal ordinance violation for solicitation. Your counsel, Ms. Carr, is present here in the courtroom with me. And Ms. Carr, what are we doing with Ms. Jameson's case?
If Your Honor is willing to allow her to resolve today, we'd be asking that you give her time served.
Ms. Jameson, if you want to resolve your case today, then the offer would be an adjudication time served.
Perfect.
All right. Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. And you can put your hand down. Ms. Jameson, do you understand everything we've discussed so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest?
All right, I accept your plea and find that it's freely and voluntarily given. Once again, your sentence will be an adjudication, time served. Good luck to you.
Thank you.
Have a good
Thank
day,
you.
Sarah.
Thanks.
All right, on page 2 will be Nancy Lesser.
Judge, they had to send her back to her cell. She's going to be a medical reset.
Okay, all right, thank you.
Thank you, Brian.
On page 11, Raymond Arnold.
Mr. Arnold, as to count 1, it's a misdemeanor.
Yes, I do see that. All right, Mr. Arnold, for the record, you're before the court this morning on 2 misdemeanor capiases. Count 1 is for trespassing. 2 is a municipal ordinance violation that is also for trespassing. I find probable cause. I have counsel for Mr. Romero, who's present with you, is representing you on count 1. And your counsel, Ms. Carr, is present with me in the courtroom for count 2. So,
Judge, in respect, Mr. Arnold, he wishes to resolve the state offense.
Time served.
Your Honor, I'd be asking for time served as to count 2 as well.
right. So, Mr. Arnold, if you want to resolve the case today, it would be an adjudication, time served on both.
Yes.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. And Mr. Arnold, do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorneys?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
Thank you, Mr. Arnold. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served, and since these are trespass charges, there will be a no return order with regard to the location that these incidents occurred at. Do you understand that, sir?
Yes.
Thank you very much. Good luck to you.
Have a good day.
Enrique Vargas Torres, was that a reset on page 15?
It was medical loan, Judge.
He was a medical loan? Okay, I just want to make sure I thought so.
See what city it's out of.
It's also a reset, you mean?
Sierra was here earlier also on page 20. What did he do with Mr. Sierra's case?
Violations of probation, so
Yeah, that
Yes,
was
so
the case
he's-
Mr. Jones was here on.
Yes, so Victor Sierra, we already addressed, it's gonna remain in place since he has the VOP tomorrow.
okay. And the
And-
bonds remained on counts 3 and 4?
Yes,
Okay,
that's
thank you.
correct.
You have Sherrard Green on the docket.
Yes. Let me just find.
Rod Green is approaching, Judge. What page is Mr. Green on?
33. All right, good morning, Mr. Green. Mr. Green, you're before the court this morning on 2 counts. 1 is for a felony probation violation, which has a no bond hold. You have a hearing before your division judge to address that matter tomorrow morning. 2 is a misdemeanor capias. That's a municipal ordinance violation for trespassing. I find probable cause.
Your Honor?
Yes.
I have no objection to, and he should be R1 on count 1. I don't see any stated basis for the violation of probation. And I don't know that, I'm not aware that a failure to appear on a municipal ordinance would be considered a violation of his probation. It's not about, I've got it. It's not about the incident occurring, it's about, because the only basis stated by the officer would appear to be the capias he was arresting him on. He just needs to contact, one, he needs to contact his probation officer upon his release. Two, I don't know if the clerk's office may already have set this for a VOP, so he'd probably be in his best interest in an abundance of caution to show up before his judge.
That is set for tomorrow morning. Okay, and Ms. Carr, what are we doing on the municipal ordinance case?
And I think just until he is able to resolve that situation with the felony, I'd be asking for an ROR as a count two, if that's okay with Your Honor. But Mr. Green, please show up to court for the municipal ordinance, okay?
Tomorrow.
All right, so, Mr. Green, I'm going to ROR you on both of these counts. As you heard, there's a hearing scheduled before your division judge tomorrow morning for the VOP. And as the attorneys have all stated, it would probably be in your best interest to attend that hearing just to address the matter and see what's going on with it. As to the municipal ordinance case, you're being released on that as well. That does not necessarily mean that's the end of the case, which means it will be your responsibility to follow up with your attorneys in the clerk's office so that you know about any future court dates that you have to be present for. Do you understand that?
Yes, ma'am.
Okay. All right, thank you. Good luck to you, sir.
Good day, Mr. Green.
And Ms. Carr, is that all that I have for you?
Yeah, thank you so much. I think that's everything.
Ms. Carr, do you have orders that you need me to sign?
I do, Your Honor. I have one more to prepare and then.
Okay, that's fine. Just give them to me when you're ready. All right, I'm going to continue on now. Next will be Judon Robertson.
I believe North Broward.
No problem, Your Honor.
Thank you. All right, good morning, Mr. Robertson.
How you doing, ma'am?
I am well. Mr. Robinson, you're before the court on 4 charges. Count 1 is for burglary of an unoccupied conveyance, unarmed. 2 is for fraud, use, or possession of identification of another person without consent. 3 is first-degree petty theft. 4 is criminal mischief, $200 or less. I find probable cause, and I will hear from the parties.
Judge, while Mr. Linder is looking that up, I don't believe Mr. Roberson is in a position to post much of a monetary bond at all. And I would ask the court, if his prior record is not extensive, to consider pretrial release for him.
Your Honor, I'm going to be requesting a $3,500 bond on count 1. He's currently being supervised in Dade County for false imprisonment and felony battery. What concerns me is the offense date of that case was August 19th, 2018. The offense date here is July 23rd, 2019. So while that case was pending, he allegedly committed these new law offenses, showing
It's on Andrews Avenue.
also has sorry, Judge, I'm just waiting for this information. showing
Good in my mental program.
battery 2011. They were dropped, Your Honor, in 2013. I see one arrest and date for burglary of a conveyance. I see another one for organized fraud, grand theft, and approximately 25 counts of check fraud. Would appear all of his other cases, I see about 7 other arrests and date, they were all dropped as well.
Well, it seems like a lot of charges have been dropped against Mr. Roberson, Judge, and I know that maybe in a domestic violence type of case, that's proper for the court to consider, but we don't know why those charges were dropped, but the state attorney's office apparently felt that they could not proceed for one reason or another. So I think to take those charges that have been dropped into account in deciding what's an appropriate resolution to Mr. Roberson's magistrate hearing is not really relevant. I think the court can look at convictions, but arrests where someone is presumed to be innocent and a charge is dropped is something that should not be considered.
All right, I'm going to set the bond on count 1 at $1,000, and the other standard bonds will remain in place. Thank you. Good luck, Mr. Roberson.
Can I ask you a question, please?
As long as it's not about the facts of your case, sir.
No, it's about my programs, because I go to JDP every day. My mental health bus come pick me up every day. And I wanted to know, can I go back there? I can't, because I was doing good on my program. I like my program. They give me my medication and stuff.
Is that can I just see that paper for a minute? Is that a program that you're doing while you've been in custody?
Yes, that's the program that I was going to my I was going on my mental health bus, and they took me into custody. That's what I was doing. I go there Monday through Friday, 8 o'clock in the morning to 3 p.m.
Okay, what I'm going to do, Mr. Roberson, is I'm going to have Mr. Reedy, who's present in the courtroom with me, pass that information along to your assigned public defender so that they can talk to your division judge about that and see how best to handle that situation, okay?
Yes, ma'am.
All right, thank you. Mr. Reedy, you might want to let them know that there's some other issues there. Thank you. Appreciate it. Okay, next will be Daniel Kostroff. Good morning, Mr. Kostroff. All right, Mr. Kostroff, you're before the court this morning. There's a total of 13 charges. One is a traffic capias. That relates to driving while license suspended. 2, 3, and 4 are felony capiases. 5, 6, and 7 are felony violations of pretrial. 8 is a felony capias. 9 and 10 are each a felony capias, and 11, 12, and 13 are felony violations of pretrial. Counts 2 through 13 are each no bond and not for magistrate. I find probable cause for these charges. And I do see, Mr. Kostroff, you are set to have a hearing before your division judge tomorrow morning. So in light of that, I'm going to leave the bond in place on count 1. Thank you. Ferdinand.
Here's your question, Judge. Ma'am.
Thank you. Good morning, Mr. Ferdinand. You're before the court this morning on a total of 11 charges. Count 1 is for burglary of an unoccupied conveyance unarmed. Counts 2 through 11 are each felony violations of pretrial warrants. Those each have a no bond hold and are not for magistrate. I find probable cause, and I'll hear from the parties on count 1.
Considering it, $500?
$3,500 bond on count 1.
3,500.
Oh, Judge, I'm gonna be requesting 1,000 considering no bond holds in this third-degree felony.
Looks like 3 different felonies.
Set the bond on count 1 at $2,000. John Schaefer.
Please approach the judge.
Thank you. Good morning, Mr. Schaefer. Mr. Schaefer, you're before the court on 1 charge for second-degree petty theft, third or subsequent offense. I find probable cause, and I will hear from the parties.
Judge, unfortunately, speaking with Mr. Schaefer, he's not gonna be able to afford the monetary bond associated with this case. He's 49, been here for 36 years now in our community. He's working at a place called Destination Direct in their customer service department. He's been there for about 1 year. Now, he's living in Fort Lauderdale right now at a place called Project Soar. He's been there for about 3 months. He pays about $150 a week there, but he can't call anyone to post his bond. He does have prior contact with the criminal justice system, but I believe it was last year in September. So I'm asking on this nonviolent offense for pretrial release on Mr. Schaefer's behalf.
Looks like he was put on pretrial release last year for his last theft, so I'm just checking to see if there were any issues. Well, I'm asking pretrial to check. I believe it was a felony. And what was he taking off when he got downfiled? Or it would appear pretty much from 2011 to 2018, Mr. Schaefer was in state prison for aggravated battery, aggravated assault, and possession of cocaine. His most recent release was in February 6th of 2018. He was then arrested last September for a felony theft. He was placed on pretrial. Oh, that's right, Your Honor. He's on probation right now before Judge Gottlieb for that misdemeanor. The theft was reduced to a misdemeanor. He pled out to resisting without violence, paraphernalia, and theft, and was placed on 6 months probation on December 2nd by Judge Gottlieb.
2019?
Yes, he's already had a warrant issued once because he didn't show up to, didn't report to probation. When he was picked up on the VOP, Judge Gottlieb decided to dismiss the warrant, but that's an additional cause for concern about him showing up in court and complying with pretrial.
Judge, I believe the incident location was Publix, various items. But the last time, from what I believe, if I heard correctly, when he was placed on pretrial, not probation, I didn't hear that he had any violations of his pretrial. So based on that, I'm still standing by my request of pretrial release.
Well, I understand that he didn't have any issues during the couple of months he was on pretrial. My bigger concern is that he's currently on probation for a theft charge, and he's now been charged with a new theft charge. So in light of that, I'm going to leave the standard bond in place. There will be a no return order to the Publix for this incident allegedly occurred at. Mr. Schaefer, do you understand that the no return order means you're not to return to that Publix until further order of the court?
Yes, Your Honor.
Thank you. Joshua Braddock. Good morning, Mr. Braddock.
Judge, Mr. Braddock advises he has private counsel, Mr. Eric Clayman.
Has he already been retained? Mr. Braddock?
Yes, ma'am.
Has this,
Yes, ma'am.
has your attorney already been retained
Yes, ma'am.
for this specific arrest?
Yes, ma'am. I'm sure my family talked to him yesterday.
Well, you're sure that they did, or you know that they did?
I know that they did. I also have a court date tomorrow morning at 8:30, Judge Coleman.
Yes, that's correct. Okay, so here's what I will do. Mr. Braddock, just for the record, you're before the court this morning on a charge for loitering or prowling, and then counts 2, 3, and 4 are each felony probation violations, which have no bond holds. And you are correct, you do have a hearing tomorrow morning for your division judge.
Yes, ma'am.
All right, so I find probable cause for the charges, and since you have the VOP hearing tomorrow morning, I'm just gonna leave the $25 bond in place on the first charge, all right? Okay, thank you, good luck to you, sir. Anthony Shaw,
North Broward.
thank you. Good morning, Mr. Shaw.
Good morning, Your Honor.
Mr. Shaw, you're before the court on 7 charges. Count 1 is for unlawful possession of personal identification of another. 2, possession of cocaine. 3, possession or use of drug paraphernalia. 4, grand theft auto. 5, passing a forged or falsely embossed or altered credit card. 6, fraud uttering a false instrument. 7 is fraud or use of identification without consent, victim 60 years of age or older. I find probable cause for these charges, and I will hear from the parties.
Your Honor, may I speak?
One moment, Mr. Shaw. Mr. Reedy is present in the courtroom with me. He is the representative from the Public Defender's Office who's representing you today, so let me hear from him, and then if there's still something you want to say, we'll address it.
Your Honor, well, first, I'm going to ask that the court keep all the bonds in place.
Okay.
It's concerning to me, if you, going by the arrest affidavit, that's he allegedly stole the victim's car, his personal property, on August 20th of last year. When he was arrested yesterday, several months later, he still had the victim's Social Security card and Visa debit card in his pocket. The fact that he's still carrying that debit card gives me concern he still has intent of using it. If not, what's he carrying it around for? And as I'm showing, he has a pending DWS habitual offender from last year, possession of PVP 2015, possession of PVP 2014, fleeing and eluding 2012, 22-month state prison, possession of cocaine 2011, VOP 22-month state prison, 09 trafficking methamphetamine, 22-month state prison.
Judge, Mr. Shaw has been a resident of South Florida for 15 years. I believe most of his priors involved drugs. He has been on supervision before and successfully completed it. He lives with a friend. He had a job, but unfortunately he lost the job. He advised me he was a legal assistant. He's been in the hospital basically since December with some pretty serious ailments. And as the court can see, he's got a heavily bandaged right arm, which he advised me is actually an open wound. So he needs to get some medical attention, and from what he tells me, he's not receiving sufficient medical attention inside the jail. So I would ask the court to consider pretrial release for Mr. Shaw.
Just so the court's aware, I'm showing that Mr. Shaw, he was placed on pretrial on that pending DWS habitual offender. I've been advised by pretrial, within a month of being placed on pretrial, it was revoked.
Can I speak, Your Honor?
Okay, so Mr. Shaw, if you want to tell me something, I'm going to let you, but I do not want you to say anything about the facts of your case. Do you understand that?
Yes, Your Honor.
We're just talking
Okay.
about bond and release conditions today.
Correct, Your Honor.
All right, go ahead.
Well, okay, Your Honor, I've been in the hospital since the evening of December 24th for over almost a month here.
Okay.
My condition is life-threatening, and as you can see, it's marked 127. I'm not, I don't want to talk about my case, but just to let you know, wherever these came from, I just went to court. I signed out of the hospital to go to court and clear this issue up and make sure that this was taken care of. And my court cases was resolved through pre-trial and through the court system by Judge Martin Feeney. And I successfully completed that, went to court on time and everything. But my condition is for blood poisoning and sepsis, and I need to get hospitalized, IV treatment and hospitalization treatment. And I'm asking, please, so I can get pretrial release. I follow conditions of the court. I'm not sure why this came up a year later or where it came from, but I'm not going to get into the court. I'll have my day in court. I understand you have a job to do, but I'm respecting your word, John, and I'm asking for a chance to go to the hospital. It's open now, and I need to get treatment, please, man.
All right, did some research. Here's what happened. He failed to appear at arraignment August 30th.
Which the court, they mailed the court notice to a previous address,
Okay.
and you can look up on the system and see that.
Okay, all right,
And
hold on, Mr. Shaw, hold on. I got you. Let me just hear from the state, and then I'm going to make a decision. Just hang on a second.
He had a hearing on the 23rd, a week ago, where he resolved the DWS habitual offender case. It still holds true, though, that he failed to appear, and his pretrial was revoked by Judge Fine.
All right.
That's not true.
Okay, hold on a second.
I went to court. I signed out of the hospital to go to court. And
Okay.
it was clear. If you look at the no-show, it was
I
at
got it,
arraignment.
Mr. Shaw, I got it.
I'm sorry, Your Honor.
That's all right, just hang on a second. You gotta give me a second to think. All right,
It's been an entire year.
I'm willing to put Mr. Shaw on pretrial, but Mr. Shaw, you would be subjected to random drug and alcohol testing as a part of that. Do you understand that?
Yes, ma'am. Thank you, Your Honor.
All right,
Thank you so much.
a couple of things that are important for you to know, okay?
Yes.
Number one, you're going to get information before you are released regarding pretrial. You must report to them within 24 hours. I understand that you have some medical issues going on, but if you fail to report to pretrial, as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, Your Honor.
All right, additionally, as I said, a condition of your release will be that you are subjected to random drug and alcohol testing, and you said that you understand that, correct?
I do, Your Honor.
All right, there will also be an order of no victim contact. That means that you are not to have any contact with this alleged victim. That means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, Your Honor.
All right.
Thank you so much.
And Mr. Shaw, I understand that you're having the medical issues. I want you to get attention for that. But if you fail to appear at your court dates, then you understand that a judge may issue a warrant for your arrest, and pretrial may make a recommendation that your pretrial services be revoked. Do you understand that?
Yes, Your Honor.
All right.
Thank you.
You're
All right,
welcome.
good luck, Mr. Shaw.
Thank you, sir.
Yes, they're all going to be put on pretrial. Jesus Morales.
Here, Judge Jermaine.
Thank you. Good morning, Mr. Morales. Mr. Morales, you're before the court on 2 charges. Count 1 is for aggravated battery with a deadly weapon. Count 2 is for discharge of a firearm in public. I find probable cause for these charges, and I will hear from the parties.
Your Honor, Mr. Morales, from what I can tell, has no history. That being said, I am requesting a $25,000 bond, pretrial release of the GPS monitor, no victim contact, no contact with this co-arrestee, John, who's arrested as John Pierce, no possession of any firearms, weapons, ammunition, Your Honor. I'm noting the injury suffered by the victim, that specifically suffering head injuries, and Your Honor. This victim, and I can tell you, suffered a fractured skull. Brain matter was showing. Your Honor, I can also advise the court, and I've spoken with a detective in this matter, that one of the bullets actually grazed the victim's head that was fired by Mr. Morales. So obviously, I do have a great concern for the alleged victim in this matter.
Judge, we were going to be requesting $5,000 on Mr. Morales' behalf. As you heard, he has no prior record. He's a registered voter. My understanding, he's been here his whole entire life. He's self-employed. He's a mechanic. He makes, on an average, about $250. He has good weeks, he has bad weeks, but the average comes out to about $250. He lives in Fort Lauderdale with his spouse, where they've been renting the same apartment for the last 6 months. Their monthly rent is about $750, so you could tell as far as this rent that they pay indicates as far as where they're at financially, so they're not going to be able to come up with $25,000. I understand the seriousness of the allegations, so if the court also wanted to impose and place Mr. Morales on some sort of supervision, that would be fine, but unfortunately he's not going to be able to afford $25,000, Judge.
He has no prior.
Just note the strength of the evidence also as a witness identified him. And also noting that he went into the house, came back out, the victim was already, my understanding, was unconscious on the ground, and he continued to kick him in the head.
There's also some inappropriate conduct referred to by the victim against Mr. Morales' girlfriend. Not to say that justifies anything, but I think that it's a factor to be considered.
I understand that there's some background information going on here per the allegations that are included in the probable cause affidavit, but even if I were to take that as true, that never justifies the type of force that was used in this case. I understand that sometimes tempers run hot, especially when you feel that you're protecting someone, but in this case, to note the injuries that were sustained by the victim, this is a very extreme allegation that's been made against Mr. Morales. Bond on count 1 is going to be set at $15,000.
I'm sorry, what did you say, Judge?
$15,000.
Okay.
If Mr. Morales posts his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact. Mr. Morales, no victim contact means that you are not to have any contact with the alleged victim in this case, no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, Your Honor.
Additionally, there will be an order that Mr. Morales possess no weapons, firearms, or ammunition. If he is in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Additionally, I will impose an order that he have no contact with the co-defendant, John Pierce, until further order of the court. Mr. Morales, do you understand those release conditions?
Yes, Your Honor.
Thank you.
Thank you very much.
Next will be John Pierce. Morning, Mr. Pierce.
Good morning, Your Honor.
Mr. Pierce, you're before the court on 4 charges. Count 1 is for burglary of an unoccupied dwelling unarmed. 2, possession of alprazolam. 3, trafficking cocaine, 28 less than 200 grams. 4 is for obstruction. If you would, just give me one moment to read the supplemental report that's been provided by the state.
I have reviewed it.
I need a moment if Mr. Romero wants to go first.
No, I'll wait for the state judge.
I'm a little bit confused because the name, I understand that this individual was originally booked in as John Doe. The name that's provided in the supplemental is Julian Brown, and he's showing as
Yes.
John Pierce.
Well, because he's not John Pierce.
Okay.
If you look at the booking photo, Your Honor, his name is Julian Brown.
Yes. I do see that in the booking information.
I can't hear the state judge.
Sorry, will you just use Mr. Reedy's microphone? Thank you.
I first spoke with Detective Cook at the Hollywood Police Department. When Mr. Brown was arrested and they asked him for his name, he refused to give any name.
Yes.
When they tried to take his photo, he kept turning, wouldn't allow them to take a picture of his photo. And from what Detective Cook advised me, he kept flashing gang signs. I guess when he was brought into the jail, he gave the name John Pierce, which is clearly not his name. He also, if I may approach Your Honor. A printout from Mr. Brown's photo showing his true identity.
See that? I just, as a side note, now that this is coming to light, then in the prior case, since we have a pretrial no contact order with John Pierce.
And frankly, that's why I was waiting to get the information, but that's why I stated the person that was arrested as John Pierce, and I was going to clarify that, Your Honor. You got to it before.
Okay, so then we'll have to clarify that with pretrial and the no contact order. All right.
They can keep, and Your Honor, they can keep the John Pierce. It's just they could put an AKA. I'm just.
Okay. Pre-
I wasn't- I
Pretrial will
wasn't
take
real.
care of it. All right.
Yes.
Okay, all right. Well, notwithstanding the name issue, I do find probable cause for the charges, so now let me hear the rest of it.
Yes, Your Honor. On the burglary dwelling, I'm going to be asking for a $15,000 bond. As you can see, based on the allegations, Mr. Pierce waited till after the victim was attacked, laying unconscious, and decided to take advantage of that opportunity, going into the home without permission and stealing the victim's property. And this was also witnessed by the neighbor. As you can see, he was in possession of a significant amount of cocaine, and if convicted of count 3, faces a 3-year minimum mandatory sentence. I don't see any history, but frankly, I don't know that I can feel that confident in the information I have, considering the lengths that Mr. Brown went to avoid his identity being known. As you can see, there's no social security number provided, no information provided to Hollywood. So I do have a concern about his future appearance in court. I'm going to be requesting a GPS monitor as well on this case. I don't see, and obviously, no victim contact, no contact with his co-arrestee, Mr. Morales. Julian. Yes.
Arrow?
Judge, there's certainly a difference as far as how the name John Pierce came about. My understanding, I'll just tell you what happened this morning when this gentleman came forward and he spoke to our interview. He was very upfront. He goes, "John Pierce is not my name. My name is Julian Brown." When I proceeded to speak to him, he advised me his name was Julian Brown. I believe when he was arrested, he was maybe exercising his right to remain silent, not giving any sort of identification. So I believe the officers wanted to label him John Doe, and I believe maybe he was close to a street in Hollywood. I believe there's Pierce Street, and hence I believe that's how John Pierce came about. But we don't know. I mean, we won't know until sometime in the future. We won't know how that came about through discovery. But he is 24 years old, Judge. You heard he has no prior contacts. He is working. He works at a restaurant called Zuma Restaurant, which is located in Miami. He's a server. Unfortunately, financially, it's not going too well for him right now. He's homeless. He owns no sort of property, no money in the bank, Judge. Basically, there's nothing he can afford now. He does keep in contact with the mother of his child. My understanding, she works as a server or in something like that. Judge, if the court were inclined to set somewhere around the neighborhood of a $4,000 bond on one, a bond reduction on count 3 to $4,000. I'm going to be requesting a total bond of $9,100 on Mr. Brown's behalf.
On count 1 will be set at $5,000. The other standard bonds will remain in place. If Mr. Brown does post his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. There will be an order of no victim contact. Mr. Brown, whether you know this person or not, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, sir.
There will also be an order that he is not to have any contact with his co-defendant, Mr. Morales, until further order of the court. Mr. Pierce, do you understand that release condition?
Yes, sir.
Thank you. John Shalev.
Medical judge?
Okay, thank you. Joseph Evans.
Is here present, Judge Main?
Thank you. Good morning, Mr. Evans. Mr. Evans, you're before the court on 3 charges. Count 1 is for possession of cocaine. 2 is a tinting violation that is not for magistrate. 3 is a felony probation violation which has a no bond hold. I find probable cause. Do the parties wish to be heard on count 1?
Judge, he has a no bond hold, nothing to add from the defense.
All right, in light of that, the standard bond will remain in place on count 1. Thank you. Stephen Woods.
Believe North Broward?
North Broward.
Thank you. Okay, you want me to put him on a recall? He's, deputy, I'm gonna put him on a recall so that Mr. Reedy can call and speak to him.
Okay,
Okay,
no problem.
thank you. Just let me know when he's ready, Mr. Reedy. Next will be Ricardo Nuno.
Judge, I've been advised he's in regular court.
Okay, is he, Mr. Linder, you wanna check and see what? Yes. Yes. Okay. Okay, let me just, okay. Thank you. Okay. All right, so we'll have him reset. Wendell Jones.
He's here. And Judge, approaching. Come on up,
Thank you.
Mr. Jones.
Good morning, Mr. Jones. Mr. Jones, you're before the court on 3 charges. Count 1 is for failure to register a motor vehicle. 2, driving while license suspended. 3 is a felony probation violation, which has a no bond hold. I find probable cause. Do the parties wish to be heard on count 2?
Judge, considering count 2 is a misdemeanor offense and he's on probation on a felony offense,
Yes.
would the court consider ROR so Dade County can pick him up?
It's fine, as long as he understands he's gonna wait. He's not going up tomorrow, or going down there tomorrow.
Sure.
And he's not getting game time anymore in Broward. And if he gets a court date issued while he's down in Dade, and he fails to appear, there's gonna be a KPS warrant for his arrest in Broward. I don't know if all that was explained to you.
What I asked him, if he wants to eventually try and get out, if the court were not inclined to go ahead and release him ROR, he would then have to post a bond anyway in order to try and go to Dade County and deal with this violation. So rather than him paying $100, Judge, I'm just trying to speed the process along. As Mr. Lender is aware, he's not going to be probably resolving this case because he's on probation on a felony offense that would not be in his best interest. So the first step is trying to get this hold alleviated.
All right, so I just want to make sure, Mr. Jones, you understand everything that we discussed, right?
Yes, ma'am.
Okay. All right, then in light of that, I will grant the ROR on count 2, and the jail will notify Dade County so that they can come get him when they're ready. All right, thank you. Michael Hisson.
He's approaching, Judge Main.
Thank
Come on
you.
up, sir.
Good morning, Mr. Hisson.
Morning.
Mr. Hisson, you're before the court on 1 charge for aggravated assault with a deadly weapon without intent to kill. I find probable cause, and I'll hear from the parties.
Judge, from what Mr. Hisson advised me, he's not working, he's on disability. He is homeless financially. From what he told me, he has no one to call to help post his monetary bond.
Looking up his history, but even assuming that there is no history, I have some serious concerns here. I have concerns about Mr. Hisson's mental health. I have concerns where there's an allegation that a resident of Fort Lauderdale just going for their morning walk says hello to someone, and it results in that other person pulling a knife on them. I can tell you that Mr. Hisson, it appears that there have been complaints of violence against Mr. Hisson in the past, because I see I'm getting a hit that protection orders have been issued against him in the past. Yes, one was issued in 2019 in Cook County, Illinois. That's in effect till April 21st, 2021. Getting hits, yes, an arrest for battery and assault in 2019 in Illinois. Previous DUI out of Illinois. Disturbing the Peace 2019 in October in Colorado. And he just was arrested, maybe got an NTA for, yes, for a municipal ordinance paraphernalia. Middle of this month. My recommendation is a $5,000 bond, no victim contact.
All right, at this time, I'm going to set the bond at $5,000 and place an order of no victim contact. Mr. Hisson, I don't know if you know this person or not. Whether you do or not, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Do I plead not guilty now, or do I get a court date?
You're going to get a court date, sir. Thank you. David Manking.
Mr. Manking is approaching, Judge. He's here at Maine. Come on up, Mr. Manking.
Thank you.
Oh, he went to, Judge, he's recall?
Okay, that's fine. Just let me know when he's ready.
Yep.
Next will be Salvatore Bisecco.
North Broward?
North Broward, John.
Thank you. Good morning, Mr. Bisecco.
Good morning.
Mr. Bisecco, you're before the court on 2 charges. Count 1 is for possession of cocaine. 2 is for a felony probation violation, which has a no bond hold. I find probable cause. Do the parties wish to be heard on count 1?
No, Your Honor, I'm going to call his mom after court.
Okay. All right. So the standard bond will remain in place. And Mr. Bisecco, you'll be seeing your division judge shortly. Good luck.
Can I ask one question?
Yes, sir.
Would you happen to have a time frame on when I'd be seeing her? Like,
Let me see. Is there already a VOP hearing set for him? Oh, it's out of Palm Beach County? Okay. It's, Mr. Bisecco, since the VOP is in Palm Beach, I don't have access to their information. But from what Mr. Reedy's telling me, he's going to speak to your mother today, so they'll be able to get you some more information later on, okay? Good luck.
All right, thank you.
Ready on Mr. Woods, Judge.
Okay, hang on one second. We have Mr. Manking at Maine.
Yes, sir.
All right. Good morning, Mr. Manking.
Good morning, ma'am.
You're before the court on 3 charges. Count 1 is for burglary of an occupied dwelling unarmed. 2 is first-degree petty theft. 3 is a traffic capias related to a charge for driving with a suspended driver's license. I find probable cause, and I'll hear from the parties.
I see no history. I'm requesting a $10,000 bond. I'm concerned he broke into a neighbor's home who happened to come home while he was still in the home, creating a potentially dangerous situation. And now this resident has to go forward knowing that the person that broke into her home is right across the street from her.
Judge, speaking with Mr. Manking, unfortunately, he's not going to be able to afford to post anything. As you heard, he has basically no priors. He's 44 years old, been living in South Florida for over 20 years. Right now, from what he advised me. He works local events. He worked at a local event last week, cleaning, and he got paid about $10 an hour. Where he's been residing at, and Davy's been there for about 1 year. He lives there with a roommate, and his share is about $150 a week. But Judge, he can't afford anything, so that's why he's asked me to ask the court for a pretrial release.
Say he has no priors.
No, it looks like his prior arrests were, ended up getting dropped. I mean, other than the DWS that he failed to appear in court on.
Correct. Not willing to ROR him to pretrial based on the allegations here, entering someone's home with her coming in while he's still there. And even if I give him a reduced bond and put him on pretrial, it's gonna be with the GPS because of the, the very limited distance between them based on the residences that I'm seeing here. So do you wanna make a recommendation for a reduced bond, Mr. Romero?
Judge, unfortunately, he can't afford anything.
To set the bond on count 1 at $2,500. The other standard bonds will remain in place. If Mr. Manking does post his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be a no return order, which means Mr. Manking is not to return to the residence that this allegedly occurred at, and there will be a no victim contact order. Because I'm ordering that he would be placed on a level 2 GPS, that would include a 500-foot stay away order from the victim, which is obviously very important considering the proximity of the residences. So Mr. Manking, so that you understand, the no victim contact order would mean you would have to remain 500 feet or more away from the victim at all times. That would also mean no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
You understand?
Yes, ma'am.
Thank you.
Judge, just for
That's correct.
clarification, his residence is within 500 feet, so is the court's intent that he can't go back to his own residence?
Based on what's going on here, that's what I'm gonna order, Mr. Romero. I mean, I'm already giving him the reduced bond in exchange for that, so if that means that he has to find a different residence, then that's what it's gonna have to mean for the time being. Kelvin Jackson.
He's approaching, Judge. Good morning.
Good morning, Mr. Jackson. Mr. Jackson, you're before the court this morning on 2 charges. Count 1 is for aggravated assault with a deadly weapon without intent to kill. 2 is for improper exhibit of a firearm or dangerous weapon. I find probable cause, and I'll hear from the parties.
Your Honor, I see no history for requesting a $5,000 bond. No victim contact, no return, no possession of any firearms, weapons, ammunition until further order of the court.
Judge, under the circumstances, reasonable.
Okay. All right, in light of that, bond on count 1 will be set at $5,000. As requested, there will be a no victim contact order, as well as a no return order. Mr. Jackson, that means that you are not to return to the location that this allegedly occurred at. It also means that you're not to be in the same place at the same time of the alleged victims in this case. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, Your Honor, but
Hold on. Additionally, I'm going to impose an order that you possess no firearms, weapons, or ammunition until further order of the court. That means that if you are in possession of those items, then you must surrender them to local law enforcement until further order of the court. Do you understand that, sir?
yes, ma'am.
Thank you.
Judge, one moment. I believe Mr. Jackson wants me to ask. He wants to ask me a question.
Go ahead. Go ahead.
Judge, I believe what Mr. Jackson has asked me to ask the court is reasonable. My understanding is, I believe some of his belongings may have been in the vehicle. He wants an order allowing him, not him, he's gonna have someone unrelated, a friend or family member, go there and just ask for his property.
Well, as long as it's not him, he doesn't need an order from me because it's just a no victim contact for him. All right?
Okay, thank you.
Thank you. We'll go back to, Mr. Reedy, are you ready for Mr. Woods' case?
Yes, Your Honor.
Okay.
Is North Broward.
Thank you. Let's go back to Mr. Stephen Woods. North Broward, do you have Stephen Woods for me, please?
Yes, Your Honor. 1 moment.
Thank you. All right, good morning, Mr. Woods.
Good morning, Your Honor.
Mr. Woods, you're before the court this morning on one charge of fraud, uttering a false instrument. I find probable cause. I will hear from the parties.
Judge, I'm going to ask the court to either release Mr. Woods on his own recognizance or leave the bond at $1,000. He's been living here in Florida for 30 years. He's been living in the same location for the last 6 years. He lives by himself. He does have some pretty serious medical conditions. As the court can see, he is wheelchair bound. He indicated to me that his last contact with the criminal justice system was in 2013. So I'd ask the court to consider a pretrial release, or ROR, or leave the bond at $1,000.
Okay. Mr. Lunder?
Your Honor, I don't have an objection to an ROR. I'd ask for an order of no victim contact.
All right. Okay, so, Mr. Woods, I'm going to ROR you, which means that you will be released today. Something important for you to know is that though you will be released today, that does not mean that that's the end of this case, which means it will be your responsibility to remain in contact with your attorneys in the clerk's office so that you know about any future court dates you have to be present for. Do you understand that?
Yes, ma'am.
Okay, additionally, there is going to be an order of no victim contact. I don't know if you know the alleged victim or not, but whether you do or not, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
All right, good luck to you.
Good luck, sir.
Yeah, thank you. Brian?
Denzel LaFrance? Yes.
He's here present, Judge Amain.
Thank you. Yes. Thank you. All right. Hold on 1 second. Let me just read the charges first. All right. Good morning, Mr. LaFrance.
Morning.
Mr. LaFrance, you're before the court on 5 charges. 1, carrying a concealed firearm. 2, possession of a weapon or ammunition by a convicted felon. 3, possession of cocaine. 4, trafficking in heroin, 4 grams less than 14 grams. 5 is violation of community control in a felony case, which has a no bond hold. And Mr. Linder's indicated he wishes to be heard.
Yes, I'm sure on your findings, and it's also in the booking, it's charged as trafficking in heroin. I direct the court's attention to the probable cause affidavit, where the detective that made the arrest and authored the probable cause affidavit, Detective Tyree, in handwriting wrote in armed trafficking. So I would ask the court to take the trafficking in consideration as an armed trafficking, which is a punishable by life offense. That is also why I asked Detective Tyree, and I'm seeking a no bond hold upon a finding of proof evident or presumption great. I know the probable cause affidavit specifically mentions where the firearm was located in one of his pockets. That's why I asked Detective Tyree to present a supplemental or amended PC with more specific information as to exactly where the trafficking amount of heroin was found, and that was found in his front left pocket. Considering that both items were found directly in his possession on his person by law enforcement, I would argue that there is proof evident or presumption great.
And then we would object to that finding, Judge. From what I'm reading here, there's no mention of what the actual weight of the heroin was.
I believe it says 8 grams.
Back here. I see it in the report, Judge.
Okay.
And it's 8 grams.
Yes.
But I would object to the court making a finding of proof evident presumption great based on this report. And that is the highest standard of proof that we have in the criminal justice system. The fact that the first report doesn't even have a first-degree felony punishable by life attached to it should indicate to the court that there is something amiss here. This is not a violent offense, and I would ask the court to set bond for Mr. LaFrance, not make a finding of proof evident presumption great. If the court is inclined to make that finding, then I would ask the court to exercise its discretion and set bond for Mr. LaFrance.
Exercise discretion, considering he's, at the time of this incident, was on probation, and there's already a warrant for his arrest for robbery with a firearm, and considering now he's again in possession of a firearm.
All right. On count 4, I am going to find probable cause with regard to armed trafficking. And at this time, the court is going to make a preliminary finding of proof evident presumption great as count 4, in order that Mr. LaFrance be held without bond on that count. That is without prejudice for him to have a hearing before his division judge to further address that matter. I will hear from the parties as far as their recommendations on count 2.
On count 2, Your Honor, I'm requesting a $10,000 bond, considering the nature of the case he's on probation for.
Judge, at this time, he's going to have to go in front of his division judge to seek some sort of relief in order to eventually be released, Judge.
Okay. All right, thank you. Then, in light of that, I'll set the bond on count 2 at $10,000, and then he can address those issues with the division judge. I do see Mr. LaFrance has a hearing before his division judge tomorrow morning on the VOP issue. Raymond McClain.
He's approaching, Judge. Come on up, sir.
Thank you. Good morning, Mr. McClain.
Good morning.
Mr. McLean, you're before the court on 4 charges. Count 1 is for possession of cocaine. 2, driving while license suspended without knowledge. That is not for magistrate. Counts 3 and 4 are each felony probation violations. Those have no bond holds and have a hearing set before the division judge tomorrow morning. I find probable cause. Do the parties wish to be heard on count 1?
Judge, considering as a court date tomorrow morning, VOP no bond holds, nothing to add from the defense at this time.
Okay. All right, in light of that, that standard bond will remain in place, so Mr. McLean can go before his division judge tomorrow morning. Thank you. Joseph Marks.
I'm advised he bonded, Judge.
Okay, thank you. For the record, I find probable cause. Joshua Clark.
Please approach the judge.
Good morning, Mr. Clark.
Good morning.
Mr. Clark, you are before the court this morning on 2 charges. Count 1 is for robbery with a firearm. 2 is for wearing a mask while committing a second-degree felony. Mr. Linder, on the second count, am I missing something in the report? I don't see anything.
Bandana.
Well, I mean, it indicates that he's wearing a blue bandana and gray hoodie, but it doesn't note that it's over his face as a mask.
Your Honor, at the end of the day, frankly, that's an enhancement, so if the court's inclined to find no probable cause based on what's in the affidavit, that's fine.
And I'm going to find probable cause with regard to count 1, but not to count 2. So count 2 will be an ROR. And I'll hear from the parties on count 1.
Your Honor, on count 1, the state would be seeking a no bond hold upon a finding of proof evident or presumption grade. Frankly, the evidence is contained in the affidavit, culminating, Your Honor, with Mr. Clark confessing to his involvement in the crime and providing evidence that only someone that was involved in the crime would know, including but not limited to where the handgun used in the offense was left.
Judge would object to the court making a finding of proof evident presumption grade at this time based on a police report written by an officer who was not present during the events. The state's called no witnesses, introduced no evidence, and proof evident presumption grade is the highest standard of proof we have in the criminal justice system. In light of the fact that the state has not done anything to establish that burden, we would ask the court to set bond for Mr. Clark, or in the alternative, if the court does make a finding of proof evident presumption grade, to set a bond for Mr. Clark.
All right, I just want to note that in the probable cause affidavit, it does include information that both Mr. Clark and I believe would be a co-defendant, each made full confessions post-Miranda to law enforcement. It seems that Mr. Clark also provided information as to where the weapon involved in this was located, which is where it was in fact found. I believe there was also video surveillance captured at the victim's home of the alleged incident occurring. So based on that information that's being provided in the probable cause affidavit, the court is going to make a preliminary finding of proof evident presumption grade.
Judge?
Yes.
Since the court has found proof evident presumption grade,
Yes.
I'm going to be asking at this time for the court to consider exercising your discretion as set bond. My understanding is Mr. Clark did talk to me a little bit about this offense. My understanding is, based on this investigation, when he saw that I believe his co-defendant was basically being investigated by the police for this offense, my understanding is Mr. Clark, on his own, voluntarily went to, I believe, the West Park police station and basically surrendered himself. He cooperated with law enforcement. He gave them information pertaining to the offense. He gave them information as far as where I believe items pertaining to this offense could be obtained. He was very cooperative. He was trying to do the right thing by the co-defendant to show that the co-defendant was not involved. Having said that, Judge, my understanding is he has no prior criminal record. He's 19 years old. He graduated from Hollandale High School just last year, 2019. My understanding, he lives with his grandfather. His grandfather's a truck driver. But right now, Judge, he has no sort of criminal prior. By surrendering himself, that shows me that he is not a flight risk. He has no prior record, so I don't think he's a risk to the community by his past would show or indicate. Judge, I'm asking at this time for the court to exercise your discretion and impose a reasonable bond with pretrial release, both of them, Judge, at this time.
Did you have a monetary recommendation, Mr. Romero?
Judge, I know these are serious, but I understand he doesn't financially have much of an ability. So I was going to be asking for somewhere in the neighborhood of anywhere from $7,500 to $10,000. I know that's going to be a stretch for his grandfather. He's going to probably have to maybe sell his trucks because he's a truck driver, but it's better than seeing his grandson here in custody, Judge.
Your Honor, he should be held no bond. The defense can file an Arthur hearing. If Mr. Romero is trying to base first that he should get a bond because of his confession, then the defense can seek to have the officers or detectives testify and get the circumstances of that confession. If it's because of his lack of a past, my concern is his present, and that poses a danger to the community. He planned with his co-arrestee to rob someone that he's known for years at gunpoint. He put a gun in this person's face and robbed him at gunpoint. And that person should also have an opportunity, if he so chooses, to address the court to voice his safety concerns at an Arthur hearing.
This time, the court is willing to exercise its discretion to set a bond. The bond is going to be set at $10,000.
Your Honor, the state would object to a $10,000 bond on a robbery firearm where he has confessed to committing the robbery.
Set the bond at $10,000. If he posts that monetary bond, he will be placed on pretrial supervision with a level 1 GPS monitor. There will also be an order of no victim contact. Mr. Clark, that means no being in the same place at the same time, which shouldn't be a problem since you will be on house arrest. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, Judge.
Thank you. One moment before you take Mr. Clark, I'm also going to, can we bring him back for just a minute?
Yes, Judge.
I'm also going to order that Mr. Clark possess no weapons, firearms, or ammunition, given the allegations in this case. Mr. Clark, that means if you are in possession of any of those items, they are to be surrendered to local law enforcement. Do you understand that?
Yes, Your Honor.
Thank you. Rodney Rodriguez. Is he still medical reset?
Judge, did you say Anthony Shepard?
No. Right now I'm calling Rodney Rodriguez.
Oh, sorry.
To North Broward, I believe, Judge.
Is he back? I did not, but I noted it myself. All right. Do we have Rodney Rodriguez at North Broward?
Yes, North Broward, Your Honor, but he refused.
The state is going to ask to proceed.
All right. Let me just ask Sheila, do you have the printout so I can, the corrected booking sheet? Okay. Mr. Reedy, do you have any objection?
Yeah, I think on this type of charge, I think he really should be here.
He should, he refused.
Yeah, I know.
And the rules of procedure state quite plainly that his presence is not needed. He was given the opportunity, it was his choice.
No, I still object.
All right. Well, I will reset him till tomorrow, but if he refuses again, then we'll be proceeding without him.
That's fair enough, Judge.
Antoine Gagney.
Broward.
North Broward, Your Honor.
Thank you. Good morning, Mr. Gagney.
Good morning.
Will you staple this to that? Thank you very much. Mr. Gagney, you're before the court this morning on a charge for burglary of an unoccupied structure unarmed. I find probable cause, and I will hear from the parties.
State's requesting a $5,000 bond. He was arrested December 4th of last year on domestic violence charges. The case ended up being null prost. He was released on Tuesday, January 28th. Next day, he gets arrested for this offense.
Judge, Mr. Gagney's been a resident of South Florida all of his life. He's been living at the same residence for the last 6 years. Unfortunately, right now, he's not working, has not been able to save up any money, so he doesn't have any financial resources available to help him bond out. So I'm going to be asking the court to consider pretrial release.
Does he have any other priors besides the one case that you mentioned to me, Mr. Linder? Thank you.
Trespass and resisting without violence last year.
I'm going to be set at $3,500. There's going to be an order of no return. Mr. Gagney, that means that you're not to return to the location that this incident allegedly occurred at. Do you understand that, sir?
Yes, ma'am.
Thank you. Elmeen Shabazz.
Medical reset.
Ask the court to make a determination in probable cause.
And that's fine.
All right, at this time, I will make a probable cause finding in Mr. Shabazz's case, and we'll just reset him for bond. Anthony Shepard.
Reset, Judge.
Asking for a probable cause determination.
He's got a no bond hold, so.
So would also be his third reset.
All right, in light of that, I'll make a probable cause finding, and we'll have to reset him for bond, at a minimum on count one. All right, that brings us to the end of our morning docket for first appearances. I'll see everyone back here this afternoon for our PM docket.
Judge, do you know what time we're gonna start?
I'm sorry, what was that, Sheila? 1:30? Okay, yes, that's fine. So, Mr. Romero, it'll be 1:30, and if anyone needs more time, I understand it's almost 12:30 now, so if we need more time in the jail
1:30 is
skit,
fine.
hold
We'll
up.
be ready to go.
Okay,
Thank you.
thank you.